Good morning. Good morning. It's Tuesday. I can't believe that it is April 2nd. Replay crew, as always, love you. There will be timestamps down below for everything that we are covering today. Today, we need to talk about Alec Murdaugh getting the literal book thrown at him. I guess I can't say literal, the proverbial book thrown at him in court and getting sentenced to 40 years and over $8.7 million in restitution. We have a lot of Kohberger updates. The prosecution's real salty that they think the defense is talking to potential jurors. We knew this was going to happen. We knew this was going to happen. We talked about it at the last hearing, but we're going to talk about it again. And then some quick updates. But there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 filings in Idaho in the last few days. And then everything going on with Murdaugh. That's going to be most of what I'm covering today. I'm racing against the weather here in Middle Tennessee as well, hoping that the weather does not impact our stream. Literally had somebody out today to discuss getting a generator. I'm like, I have trials coming up, and what we can't do is be interrupted due to lack of power. So there's only been a few times that power has really impacted the stream. Hopefully it won't be today. Fingers crossed. But I also added local power for my computer, internet, and stuff. So even if the lights go off, I should still be here. So fingers crossed. All of my kids are getting actually are already out of school. So the kids school day was like, we're dismissing it like 10:30 or whatever. It's like good. Good. So with all of that, we have really a lot to cover today. So Lacey asked a question in the chat. Lacey, can members still watch the behind the scenes from last night? No, those are only live while I record them. I record the podcast with the members in the chat. And then those are live while I record them, and then we edit them, and then they come out as the podcast you know and love. So that's why we let you guys know in the member spaces and in the app when we're doing them. But those are a happen when they happen, generally on Mondays at some point in time. So with all of that, we're going to roll the intro. Law nerds, are you ready to ride? We need to talk Alec Murdaugh. We need to talk Alec Murdaugh. Are we done with this man yet? Chat, are we done? Can we be done? I'm done. Are you done? Or are you just like, we're here until the fuckery stops? I'm not sure how I feel about it. Maybe we're here till the fuckery stops. Let's get started.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Oh my God, my cats have walked on my keyboard. So my keyboard can be a keyboard for kind of any type of operating system. So I kept going to copy and paste something, and it kept pasting something instead of copying something. And I'm like, which of you was walking on my keyboard to look at the birds? Like which one of you is the guilty party? It's probably Fred. Let's just be honest. It's probably Fred. The other thing I didn't have a chance to do yet was pull up the chat from the stream. So I'm going to do that. We did record the podcast last night with members. Tomorrow's podcast will be covering the P. Diddy raids, whether or not I think the civil lawsuits had anything to do with that. Spoiler. Just for those of you who heard, it's just 5,000 of us. It's cool. Spoiler. I do think that happened. I do think that the civil lawsuits have something to do with it. And as always, I went through the civil lawsuits, but I did not go into every single detail of all of the allegations of assault et al. Because I wanted to be able to get into the law stuff without truly getting into every single allegation, because some of the allegations are particularly horrific, and those have been widely reported on. If you are interested in getting the full rundown of everything that's been alleged, we did kind of an overview of the allegations and then went into how that might play into a raid, what they might have been looking for, what kind of charges may come, what those charges mean. So a full, like, did he do it? We also talked about we also did talk about 50 Cent shading Diddy all over social media because I find it funny. I can't look away from 50 Cent throwing shade at people on social media. Like I can't. It's just when you see people who would have insider knowledge like 50 Cent, like Eminem and others, I can't stop. I just can't. And yes, I'm going to I had it in the notes for the podcast. The members asked about it, but yes, the podcast is going to have to be called Did He Do It? There's no other option. There's just no other option. There's no other option. It has to be. It just has to be Did He Do It? Why he got raided. And kind of what that means, what the lawyers have said about it. We might add a little bit of an addendum today because my amazing producer, Migalina, is like, so I have some more information. And I'm like, I've not heard anyone talk about that information. So we're going to add a little bit of an addendum. Yeah, we got a full podcast for you tomorrow. So I'll be in the chat with you at 11 a.m. when that drops. If you don't have the app, you're going to need the app because, I know you're gonna want to hear this one. If you have not gotten up to date on what's going on, I covered the Cassie Ventura lawsuit in like November on the podcast. You have to go onto my channels and videos and look for it. YouTube does not push those videos the same way that others do just because of the subject matter of those videos. That's not shade to YouTube. It's just the fact of the matter is not everybody wants videos that have those types of allegations. So YouTube is very restrained, we should say, in the reach that those videos get. So you guys summoned my cat's lawyer already? I just started streaming. Your client was maliciously altering my keyboard. I'm pretty sure I've been hacked. When I start seeing the charges to PetSmart, I'll know for sure. Chat, let me know what you're drinking. Now that my cat's lawyer is here, I have iced coffee. It had cold foam on the top, but the cold foam is now not super cold foam. It just is what it is. So with all of it, I see you guys. Justice for Fred. It was totally him. He's been carrying around one of his toys in his mouth. Both he and George have different toys that they carry around in their mouth. Orange cats, man. So different from some of the other cats I have had the pleasure of loving in my life. They're hilarious. So they've been carrying their toys around the house for like the last 2 days and hurling them. Somebody asked how I made my iced coffee. I spent too much money on my coffee maker. It is a Jura, Jura, depending on how you want to pronounce that. And it brews iced coffee. And then I threw ice in it and threw some cold foam on the top in my like frother, which the brand I forget. I will put it in the Amazon shop. I keep forgetting to do it. I'll share it on in the member spaces too. Can I share pictures in the app? If I can share pictures in the app, I'll share pictures in the app after stream of my coffee accoutrement. I'm just saying there are a lot of options for coffee makers that are not the one that I bought. Like a lot of them. Like a lot of them. I paid for more than half of my coffee maker with credit card reward points because I needed to use them by the end of the year. So I got a gift card. This is way more information than I think you guys need, but I got a gift card to Sur La Table where they sell these particular coffee makers, but they are above and beyond. They're a delight, but they're above and beyond. Thank you everyone who gifted memberships. You guys, we have a flood of new members this morning because everyone's making it rain in a good way, not in a spinny, damaging, straight line wind, lightning-y kind of a way, which is really my bigger concern around here. Because but I think all the trees that were gonna fall have, though we still have quite a lot of downed wood in our yard from the last storm, but everything's far enough away that I think we're pretty good. Lindsay, thank you to all the new members. Welcome, Fiona. Thank you so much. Leela, thank you for that. Allie, thank you for the gifted memberships. B2, thank you for the 20 gifted memberships. J. Michael RN, thank you for the 20 gifted memberships. Good to see you in the chat, friends. We're going to thank everybody who who gifted memberships, and then we're going to get on to talking about Murdaugh. P2, thank you for the 20 more gifted memberships. Maggie, thank you for the gifted memberships. We're going to talk. I've got a real quick update on Girardi. The members asked about this last night when I was recording the podcast, and I went to go peek while I was prepping for today. So we're going to talk about Girardi super fast. Like when I say super fast, don't blink. We're going to talk about Girardi super fast. Tom Girardi's trial date moved to August. It's not going to be in May. I'm kind of glad that they spaced it out. It's a federal trial. I am so over the feds having no audio feed, no video feed, no nothing. You know, Mandy Matney and a lot of others were in court yesterday for Alec Murdaugh's sentencing. They had an overflow court. You know what they did in the overflow court? They streamed from the court to the overflow court. If you can stream it from one courtroom to another, you can just stream it to us. Like, what are we doing, federal court? It annoys the ever-loving piss out of me. Everybody would have wanted to see the SBF sentencing. People want transparency in the courts. This was meant to be quick, and now I'm ranting about the federal courts. Yes, you can go sit in federal court. People want to see what's going on in their courts. People would have wanted to see what the judge had to say with Murdaugh, would have wanted to see what Murdaugh had to say to the court. We're going to read other people's accounts of it today, but it's very frustrating to me. Like, just let the people be. Let the people be. Let the people be. Let us see what's going on in court. Anyway, Tom Girardi's trial date was moved till August 6th. It had originally been set for May. It had then been set. No, it had been set for March. Then it was set for May. Now it's set for August. It might actually go in August, but we'll see. That'll be in federal court. That'll be a couple weeks long. Look, another lawyer in federal court accused of stealing from his clients. I kind of hope that the Murdaugh sentence scares the ever-living shit out of Tom Girardi, and he talks to the feds about a plea deal, and he doesn't have to put on this whole song and dance of the trial. Normally, I will chat with you guys ad nauseum about the fact that A, these allegations haven't been proven. B, you know, everyone is innocent till proven guilty. But some of the things that Girardi is facing criminal charges for have already been proven. It's like when Murdaugh went to court, some of the things Murdaugh went to federal court was already proven. So with the Girardi stuff, it's already been proven. And Girardi stole a lot more money than Murdaugh did. He doesn't have murder charges against him, but he stole a lot more money from a lot more people for a lot longer than Murdaugh did. So he should be looking at that 40 years and going, oh, fuck. I may never, well, I mean, he's in his mid-80s, so any sentence. I may never see the outside of a prison cell. He's not in custody now. So this should concern him greatly. Either way, Tom Girardi going to trial in August. I hope this sentence scares the shit out of him. Look, SBF got 25 years. Murdaugh got 40. What does that tell you about how the judge felt about a lawyer stealing from their clients versus SBF stealing from literally everybody? All right, let's talk. While we're talking about Alec Murdaugh, let's talk about Alec Murdaugh. I don't know which one's a more disgraceful member. Well, I don't know which one's a more disgraceful former member of the bar. Tom Girardi stole from many more clients for a lot longer. We're going to talk about this. After we talk about Murdaugh, somebody remind me to circle back. We'll circle back. Let's talk about Girardi. Not Girardi. We just talked about Girardi. Let's talk about Murdaugh. Alec Murdaugh, what have you done? Alec Murdaugh was sentenced to another 40 years in prison. This is on top of, well, in addition to the 2 life sentences he is serving for the conviction of murdering his wife and son, and the 27 years he is serving for the state financial crimes. His financial crimes range from stealing from his own law firm that his brother was a part of to stealing from a wide variety of clients. Today, I'm going to break down the sentencing documents and the restitution order so you can see where he's been ordered to pay restitution. Does Murdaugh being ordered to pay restitution mean that those victims will see the money? It gets very complicated to try to find that money. It's one of the reasons federal prosecutors asked to violate Murdaugh's plea deal. They said that Murdaugh was not truthful with them, particularly about where the money went. And that was one of the things they wanted him to be upfront about. Murdaugh's lawyers have gone to court saying he doesn't have any money left. There's money somewhere. His mother just passed away, but I imagine that those wills were changed so that the money does not go to Murdaugh. It goes to his son, Buster. There, all of this money didn't like poof vanish into the air. So could this money be offshore somewhere for the benefit of his family? It's possible. Do we know that for certain? No. This is the problem with trying to find money after it's been offshored. So where is the money? That's a real good question. That's a real good question. Do y'all think Dick and Jim work for free? I sure fucking don't. Not, wow, there's going to be a lot of cursing today. I can feel it in my soul. I sure don't. I sure don't. I sure don't. So let's go to a breakdown of what happened in court, or one of the breakdowns I saw from what happened in court, and then we'll move along. Emily, did you share your screen yet? No. Do you intend to do that before you stream every single time? Yeah, I do. Every single time I intend to. And then I don't. That's not where I want to be. There we go. This is coming from the state.com. They're kind of minute by minute. I did pay for the 99-cent free trial. I'm annoyed that there's still ads. Like, stop it. I paid. Stop it. It's I just want the article. Ted, sir, I just want the article. FFS. 9:48 a.m. Alec Murdaugh arrives in federal court. Alec Murdaugh was led into the courtroom surrounded by U.S. Marshals, shackled and wearing an orange South Carolina Department of Corrections jumpsuit. For all of you that are asking, hold on. The student of all things, CEG, the beginning of the podcast, or the beginning of the episode, or the beginning of the stream today. We're talking about it tomorrow. So yes, and Murdaugh is still in state prison. Murdaugh will stay in state prison. We have some editorializing. Sentencings are often an emotional affair, with testimony from victims and attorneys about the impact of the crimes. During Murdaugh's last sentencing, the state on state financial crimes, many, some of who consider Murdaugh a close friend, described the pain of discovering that this trusted attorney and friend from a prominent family had callously stolen from them. Yes. Hours of sentencing. And I think it was helpful to actually get to watch it. Today's sentencing has added a layer to the drama, as federal prosecutors last week attempted to back out of the plea deal. They asked the court to break the plea deal because they said that Murdaugh lied, which called for Murdaugh's federal sentence to be served concurrently with the state financial crime sentence. In filing, they claim Murdaugh was not truthful during a polygraph, and other interviews. In response, Murdaugh's attorneys, Jim Griffin, Dick Arputli, and Phil Barber and Maggie Fox, have filed motions asking for summaries of the interviews to be released to the public, and for prosecutors to turn over data from the polygraph exams. So that's what was pending before the sentencing began. I can't help but wondering, does Murdaugh or his lawyers want that information publicly released so that others might have a heads up, if you will? Because the Fed said that the reason they didn't want to unseal those records is because there are still ongoing investigations, and it might impede those investigations, i.e. tip off people that they are being investigated. I imagine those people probably already know. Like, if you were working with Murdaugh at this point, are you at questioning what went down? Probably. This has been going on for years at this point. 10:28 a.m. Murdaugh's attorneys have reached an agreement with federal prosecutors to continue with today's proceedings after court filings last week threw a speedy sentencing into doubt. Prosecutors said they're no longer offering a previously agreed recommendation for his sentence, while Murdaugh's attorneys have withdrawn their motion for the polygraph data. Sentencing proceeded before, I think it's Judge Gergel. I might be pronouncing it wrong, but Gergel, it's I don't know. Gergel. It's gurgle to me. I don't know. Sorry, Your Honor, if it's not gurgle, I apologize. Oh, my screen, you're right. I was just talking. I was just talking. No, their investigations, Lacey, are not complete. You're right. For all of you who are like, your screen. Yes. Look, gurgle, one of the others. Before sentencing proceeds, the judge said that he approves of the findings of the pre-sentencing report. The court has determined Alec Murdaugh owes $8,762,731.88 in restitution. I love it when they get down to the penny. They're just like, and 88 cents. For all of you coming in, you're like, I'm late. You're not. We just got rolling. It's fine. We just started. They're going to get that 88 cents. That might be all. 10:40 a.m. Alec Murdaugh addresses the court. Facing the judge, Murdaugh said that he took responsibility for his crimes, described as heavy opiate use and claimed addiction was the key factor in his thefts. Well, he's definitely said that before. He pledged to try to make his victims whole. By what? Betting with beef sticks? Like what do you tell them where the money is? If you want to make the victims whole, tell them where the money is. I don't believe for a second that it's all gone. Not for a second do I believe it's all gone. Quote from Murdaugh. I want you to know, and I want the victims to know, I am filled with sorrow. For yourself? I am filled with remorse. I am filled with guilt, Murdaugh said. I am very committed to trying to be a better person. You just want people to talk to you when you're in custody, I think. I have my empathy for this man is gone. Just absolutely gone. After seeing him testify, I really tried to keep an open mind before he testified at his murder trial. After he testified, I was like, you manipulative. I can't. Watching him gaslight his victims in real time at the state sentencing I was so done with this human. Just done. Just absolutely done. I'm like, in real time, to their face, the people that you stole from. You knew the people that you stole from. You knew how vulnerable they were. The clients that went to both Murdaugh and Girardi had suffered the worst thing that had ever happened to them and the worst thing that had ever happened to most, and knew that that money was life-changing, save your home from bankruptcy, take care of necessary medical bills, money. And you fucking stole it from them. And Murdaugh was friends with them. People who came to him because they had known him since they were kids. People who lost family members. And they came to him to make it right. And he looked them in the face, lied to them, and stole from them. The Satterfields lost their home. Like, it just, I can try to keep an open mind and see both sides of things. But after he pled guilty, the murder convictions, the gaslighting, watching him testify, I'm like, and we're done. And we're done. There are no two sides of this anymore for me, personally. I don't believe that this is all addiction driven. I think that that is a narrative for him to try to get empathy from others. I don't doubt that he had an issue with opioids, but I don't think this is all addiction driven. I just don't. So, at times, Murdaugh was hesitant and appeared to choke on his words. Like he did in trial. The former attorney, renowned for his quick thinking and ability to speak to anyone, said, "Judge, I know there's not enough time and I don't possess sufficient vocabulary to express to you in words the magnitude of what I feel about what I did. As you pointed out, for a long period of time, I am literally filled with sorrow and I am filled with guilt. Mhm. Murdaugh placed his addiction to painkillers at the heart of his thefts. Now 937 days sober, Murdaugh said of his opioid usage, quote, "One of the reasons that my addiction grew to the extremes that it did is that I was using opioids to hide from the things I was doing to people that I cared about. I hope with every cell of my existence, I hope that I would not have done the things that I did had I not been addicted to opiates." But in an interjection following Murdaugh's speech, the judge appeared unmoved. Quote, "No truly impaired person could pull off these complex transactions," Gurgle said. Instead, Murdaugh used his charm and charisma to seduce a web of conspirators by the siren song of affluence. God, Charleston, South Carolina, y'all love a siren song, don't you? Or was this, Your Honor, are you friends with Chief Justice Toll? Because Chief Justice Toll talked about the siren song of fame getting to Courthouse Becky. Is this just a colloquial to South Carolina that they just love, or is this a callback to Courthouse Becky? I don't know which, but I'm good with both. Are we all singing from the same hymn book? Because that is also a colloquialism that I loved coming up in court in South Carolina. That is not something you would generally hear in like Los Angeles. Different. The siren song of affluence to assist him in his thefts. I agree. I absolutely agree with the judge. He was actively manipulating everyone around him to pull this off. I don't know how willing some might have been, but I think some were afraid of him because he was incredibly influential and powerful. Did I say him no wrong, Nishay? I might have. Yeah. You'll be shocked that it's been a very long time since I've been to church. I apologize. And even then, I didn't often sing in public. Now we just do all the things on the internet. Okay, look, I appreciate that March Madness is going on, but I also am trying to get to the other part of this article. Okay. The judge sentences Murdaugh. U.S. District Court Judge Gurgle has sentenced Murdaugh to 480 months, 40 years, to run concurrent to his state charges. This is 10 more years than the up to 30-year sentence requested by federal prosecutor Emily Limehouse. Hey, Emily's represent. The sky's getting growly outside. It's starting to sound like a Garth Brooks song. In the weeks leading up to the sentencing and throughout the morning proceedings, the judge indicated that he was considering an upwards variance in his sentencing. At one point, the judge mused whether the sentence should serve as a warning to future lawyers who abuse their license to do good, as Gurgle said. Quote, "This verdict we make today, we make for the United States, we make for this court, we make for the interests of justice." The judge is pissed that he is a lawyer stealing from clients. Particularly pissed. It is very rare in a financial crimes case that I have seen a judge not just do an upward variance, but an upward variance above what the prosecutors asked for. The prosecutors asked for like 17 and a half to 30. To go 10 years over the top that the prosecutors asked for is deeply significant and unusual. And when you look at SBF, and I don't know if Rob's still in the chat, with SBF, it was $1 billion+ in loss. On the flip side, this is under 10 million, which I know feels like a lot, but this is under $10 million. So in the world of like large ranging financial crimes in federal courts, that's not the craziest number that federal courts have ever seen. So for him to get 40 years is quite significant. Nate, the lawyer, good to see you, friend. Nice to see you in the chat, Nate. So it's a very, very significant sentence. Then again, Murdaugh has also been convicted of the state crimes for this. Murdaugh has also been convicted for murder. So, I mean, he wasn't convicted when these crimes went down. Rob said, still here, rare for upward departure from government request. SBF gave the judge plenty of reasons if he wanted to. Wasn't SBF's loss multiple billions? Like the estimated loss multiple billions? In SBF. Good to see you, Octo. Everybody's in the chat today. It's like the place to be. We're all hiding out from the storms. I love it. So Rob said 8 billion in the chat. Thank you, Rob. I couldn't remember off the top of my head. I knew you knew because you've been following that case so closely. So the estimated loss for the collapse of STF or FTX with Sam Bankman-Fried, who is the CEO who was manipulating not just the cryptocurrency, but stealing money and a bunch of other things. 8 billion in loss. He got 25 years. The judge said on March, and if you see my last coverage of this, the judge said on March 15th in his minute notes that he was considering an upward variance. But this judge has not sentenced the others involved in this scheme as high. So it's clear that this judge was holding out that Murdaugh is the kingpin here. Murdaugh is the most culpable in this judge's mind. He has sentenced Russell Laffitte, and I don't know if he's sentenced Fleming yet. I'm going to have to double check. But he clearly sees Murdaugh as the most culpable here in sentencing him to 40 years. It's a very substantial sentence for financial crimes. Federal sentencing on financial crimes often is quite low. Or in my opinion, quite low. I am a former prosecutor. I also liked working in fraud and financial crimes, and oftentimes they have many more victims than violent crimes, and they are crimes committed not generally out of desperation. They are crimes committed with a calculated greed, entitlement, and coldness that is different than, other types of more street level crimes. You rob somebody of $200 with a gun or go into their house and steal $2,000 worth of stuff, you're going to face substantially more time generally than if you steal tens of millions of dollars through fraud or computer crimes. And that is the reality of the way crimes are sentenced. But I think violent crime and financial crimes need a little bit more of a shift, because the amount of victims of a Tom Girardi, of a Alec Murdaugh, of a Jen Shaw, the amount of victims and the damage that it does to those victims is substantial. Jen Shaw was stealing people's retirements. Alec Murdaugh and Tom Girardi were stealing people's settlements for catastrophic injuries. The amount of damage that is done, it is out of alignment for me with the federal sentencing. Truly. And I think that federal sentencing needs to look at that and stop thinking that if you steal somebody's life savings when they are in their 70s with a computer, it's less damaging somehow than taking money at gunpoint. I don't necessarily think it is less damaging, but I could rant forever. And then when you're in a position of trust, it's even worse, right? When you're their lawyer, it's worse. The breach of trust is worse. It's worse than if somebody steals your car from in front of your house. Somebody steals your car from in front of your house. It fucking sucks. It sucks, but you can deal with it, right? Your lawyer steals from you after you've been injured, lost a family member, lost a limb, been paralyzed, whatever it is, and your lawyer steals from you, and you're facing catastrophic medical bills, which is a separate rant for a separate day, and a complete change of life. And the person that you trusted to make that right for you steals your fucking money. It's worse. It's worse to me. It's absolutely worse to me. So I think there is some disparity in the federal sentencing. I think that maybe Congress sometimes looks at these crimes as like math crimes. Like, I don't understand. It's just creative accounting. No, it's not. Especially when it's someone in a position of trust. It really, you can see why this is the area of prosecution I chose to go into. Oh, it just pisses me off. It just pisses me off. So I was the one in court being like, but Your Honor, this has devastated 40 victims. It's different. Well, nobody was hurt. People are hurt. When people lose their savings and go into retirement with nothing, people are hurt. Okay. I'm going to stop ranting. I think there's room to start looking at what is behind these crimes, and looking at the entitlement that people go into these crimes with. I think Sam Bankman-Fried truly thinks, I think he honestly believes that it's creative accounting. I think Jen Shaw believes it too. Like, I don't understand why I'm in trouble. It's just like, that's what businesses do. Like, what are you mad? Like, what are you all mad about? Like, this is how the game is played. Like, what's wrong with you? I really think that's how they see these crimes. And I think that's how Murdaugh sees it too. I mean, and same with Tom Girardi. You can't steal from people who trust you without looking at them and being like, yeah, but like, I deserve it more than you do. The entitlement is just wild, right? Just pisses me off. Just pisses me off. Anyway, I am glad that he got 40 years. I'm glad that he got 40 years. Rob in the chat said SPF sentencing statement made it pretty obvious he didn't understand anything he did was wrong. I don't think he thinks it's wrong. He's like, so I get caught for it? Like, other people get away with this. I'm not going to start ranting about our Congress, because there's a lot of creative accounting that is like allowed if you're a member of Congress, stuff that anybody else would be arrested for because of insider trading. So I think maybe it stinks from the head. Like, the people writing the laws are also like, but if we benefit from the race, like, it's okay. These are games only people who are wealthy benefit from, right? These are games you only get to play in the millions of dollars range. And some people get caught and some people don't. It just pisses me off. PJ said Ryan Hall is going live in 30 minutes. I'm not surprised. The sky's very growly. It's not all the way green yet, but it's got that sus color to it. I love Ryan Hall. I love Ryan Hall. He's so great. If you guys don't follow Ryan Hall, y'all, he does weather streaming on a level that is so excellent. I also, for those of you that live local to me, rely on quite a lot is Nashville severe weather. They're fantastic, but they only cover 2 counties. Ryan Hall, y'all, covers storm outbreaks at the next level. DW, thank you for letting me end my rant in a gracious way. DW in the chat said, EDB, what is your next trial you will be streaming? Karen Reed. We'll talk about that at questioning. Karen Reed. Steve C said, will upward sentence give grounds for appeal? No, this is a plea deal. He doesn't have a right to appeal. It doesn't really matter. We're going to go to his sentencing sheet. Look, I don't think Murdaugh's murder sentence and murder case will be overturned. He's going to be on appeal for quite a while regarding that. But he is 55 years old. He has a 27-year sentence. And then when that finishes, this 40-year sentence is still going. So at 55, is this 40-year sentence kind of all? Yes. I mean, yes. So a 40-year sentence at his age is different than a 40-year sentence for a 20-year-old, right? Though with 20-year-olds, it makes them less hopeful and they can pick up more time in custody. But that's a conversation for a different day. Let's go to the sentencing sheet. Let's go to the sheet and see what the judge filled out and what else he had to say. After I've ranted about white collar crimes and other crimes of entitlement and privilege, because you got to be rich to play those games. The defendant, was it Runkle? It might have been Runkle that was talking about this. When you look at the amount of loss for Sam Bankman-Fried and his sentence, that he was sentenced to like 1 day for every couple of $1 million. Wild to me. State versus Richard Alexander Murdaugh. All of his lawyers pled guilty to counts 1 through 22. We went through the nature of the offenses on the last stream. Financial crimes, fraud, conspiracy. Imprisonment. Comes now the Honorable Judge Gergel to tell you what imprisonment you will suffer. The defendant is hereby committed to the custody of the Federal Bureau of Prisons to be imprisoned for a total term of 480 months. Said term consists of 360 months as to counts 1, 2, 3, 4, and run concurrently to one another and concurrently to all other counts. 240 months as to counts 5, 6, 7, 8 to run concurrently with one another and concurrently to all other counts. 120 months as to counts 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19 through 22 to run concurrently with one another and consecutively to all other counts. So it's the 360 plus the 120 is how you got to 480. The 240 runs concurrently in the middle there. It is so good to see you in the chat, Nick. Nick said, love Runkle. Runkle's shade is on point and is often the definition of the velvet glove. Like it is so perfect. Like I would love to see like Runkle not on YouTube, like read a bitch. Cause you know, it's going to be good. Like, you know, it's going to be good. So that's how we get to the 480, the 360 plus the 120. These terms shall run concurrently to the remainder of the undischarged state terms of imprisonment for dockets numbered reference in paragraph 189. Those are the financial crimes. Furthermore, these terms to run concurrently to the prior undischarged state terms of imprisonment in the other docket numbers. Defendant shall pay a special assessment fee of $2,200. Those are the court fees. Restitution in the amount of $102,000 is ordered jointly and severally with co-defendant Corey Fleming. I missed one. This type is breaking my brain. Restitution in the amount of $8,762,731. I can read that better. $8,762,731.88. Both due and beginning immediately. Restitution in the amount of $102,000 is ordered jointly and severally with co-defendant Corey Fleming under his docket number. Restitution in the amount of $1,414,826.54 is ordered jointly and severally with Russell Lafitte. So it's really more than 8.7 because he's responsible for the restitution fund in the amount of $100,000+, the $8.7 million in direct restitution, and then restitution joint and several with Corey Fleming and Russell Lafitte, meaning both defendants are responsible for it. The defendant is remanded to the custody of the U.S. Marshal, and then they're just going to return him back to South Carolina. Supervised release. If he ever gets outside of custody, which isn't going to happen, the defendant shall be on supervised release for 5 years. While on supervised release, he shall comply with the law, must not incur new credit charges or open additional lines of credit, like no banking. Must provide probation with financial records and reports, general terms of release. I don't think he'll ever see the outside of jail. Mandatory conditions. You must make restitution. You must cooperate in the collection of DNA. He's already done that. The nice thing about restitution is with this, money that gets put on his books can be taken for restitution. It'll be interesting to see if he is already trying to put money on other people's books for his benefit. I guarantee you, if he's not doing it, he's thought of it. Misopinionated to DNA. Every time when people get arrested, when people get sentenced, their DNA is taken and put in the database. It's generally to see if they've committed other crimes when things come up. But yes, your DNA gets taken and kept in now the DNA database. These are standard terms of supervision. We're not going over it. He's not getting released. This is what I wanted to go through, the criminal monetary penalties. These are the loss amounts and what he is ordered to pay. Parker Law Group, formerly his law firm PMPED, $4,544,730.15 to his former law firm PMPED. Will he pay it? I don't know. But PMPED paid back a lot of the clients on Murdaugh's behalf. When PMPED discovered this, mostly because of Jeannie Seckinger, the CFO, who we saw, like the way I want to hire Jeannie Seckinger as my CFO, the way we saw Jeannie Seconder unpacked this at trial. When PMPED figured it out, they sued him civilly and they paid restitution out of a lot of the lawyers' pockets, including his brother, also probably some of their malpractice insurance, and paid out their clients the direct loss amounts. So when Murdaugh was stealing from clients, the law firm paid it back. The law firm suffered the loss, and the partners individually suffered the loss. I'm sure they took it off their taxes. They suffered the loss, and now they have sued him civilly and now been ordered criminal restitution for the monies that they paid out. Palmetto State Bank, $329,913. I mean, Palmetto State Bank needs to go after those at Palmetto State Bank that allowed this to happen. If they get paid, they get paid. If they don't, they don't. Like, is my heart broken for Palmetto State Bank and all of that? Not really. I actually feel bad for the law firm. I feel like Murdaugh's brother's family and all the other lawyers there, who I have no evidence that they knew what he was doing, did the right thing and paid up. I feel for them. Are they going to see their money? Probably not. I think this should go in reverse order. I think Pamela Pinckney should get paid first, and then you go the other way around. Kumis Insurance, and no, it's not PIMPED. We're not like motherfucking PIMPs up in here. PMPED. Parker, Murdaugh, other people. Parker, Murdaugh. PMPED, not PIMP. It stands for something totally different. I see you, chat. Y'all are witty, and I love you for it. Kumis Insurance, $3.8 million. Pamela Pinckney, $13 million. The interest requirement is waived for the restitution, so it's not going to gain interest. Schedule of payments: a lump sum payment of $2,000 and restitution in the amount of $8,700,000 plus are due immediately in accordance with Segment D. Payment in equal monthly installments of $250. Chat, it's flawless. Wolf Kiara's up here going, I don't know what you heard about me. Yeah, I see you. I see all of you. I see all of you in the chat. Look, we're 50 fans over here. There's I'm not hiding it. We're absolutely 50. We're absolutely 50 fans. $250 a month. Murdaugh, I'm going to need you to get a job, sir. I'm going to need you to work while you're in custody. I'm going to need you to work. I'm going to need you to work to commence 30 days after release from imprisonment. Yeah, he's not getting released, but he can have money taken out of his books. If they find money, he can pay. I don't think he's going to be that fussed about restitution, though. He's going to be in custody the rest of his life. I don't think he's going to be that bothered. Defendant shall receive credit for all payments previously made towards the joint and several amounts. Corey Fleming, and these are the joint and several amounts that Corey Fleming owes Parker Law Group and that Corey Fleming owes Pamela Pinckney. So if Corey Fleming's already paid part of that, Murdaugh could be owed the other part of it. It just deducts as to who's paying. Russell Lucius Lafitte owes over $1 million to Parker Law Group and over $300,000 to Palmetto State Bank. And those are joint and several with Murdaugh. Is any of this going to get paid? I don't know. Preliminary order of forfeiture. They're going to take your shit, but I don't know how much shit there's left to take. Like, Herlita in the chat said, if you get Mix-a-Lot and 50 Cent equals real YouTuber. I don't know about that, but I mean, I would love to hear more of what 50 has to say about Diddy. It might be better to wait until after we see an indictment, though. Lots of Lucius going on. So these go through the forfeiture orders. Again, the government can come and take your shit. Not a lot of shit was in Murdaugh's name. There was stuff in Maggie's name. I don't know how much shit is left. Some of it's in receivership. for the boat crash and others. I just don't know if there's anything left. I truly just don't know if there's anything left. Oh, and for those of you that are new or newer, the the real YouTuber is a callback to my son who's constantly moving the needle as to whether or not I am in fact a real YouTuber. Joe Jersey said, get Jelly Roll and be a real YouTuber. We want Jelly. I do too. And he actually lives close. I'm waiting to run into like Jelly Roll at the grocery store. It's one of these days it'll happen, I'm sure. I think he's probably too famous. Not in Nashville, people are really chill about that. Like Reese Witherspoon still just goes to restaurants around here. People are fairly chill. So with all of that, all the forfeitures ordered, they'll take the property, the below described property. What is the below described property? Where is the list? Yeah, that's the thing. I don't think there's much left to forfeit. For those of you that remember the Omni in a Hellcat case, we went through the list of all of the property. There was actually stuff to seize in that case. There were a fuck ton of cars. My kid wants me to go back and see if there were any. He gave me a list of whether there were any Nissan Supras, Skylines. We know there were Hellcats. There was something else that he wanted me to look at. He's like, but did he have any of these particular cars? And I'm like, how much Fast and the Furious Tokyo Drift are you watching, son? Because I don't know what world we're living in, but a Nissan Skyline is not what's happening. Like, ever. But he wanted me to go through the list of cars for the Omni and a Hellcat. I might just have to send it to them. My 16-year-old loves cars, particularly JDM cars. Obsessed. Like obsessed. But what's not happening is him getting a racing car. No. Not at 16. He's not. I'm like, you're gonna need adult money for adult cars, my sir. Let's see. Supra is Toyota, not Nissan. I don't know things. Pink Glamour said Jelly Roll came into our hole in the wall town to speak, and we never get famous people, so it's possible you get to run into Jelly Roll. But was it Antioch? Because he's from Antioch. But he's very down for Middle Tennessee. L. Lambert said I used to drag race. It's lots of fun. Right? He can do that when he is an adult. We'll have other chats about my son and his love for vehicles another day. He's 16. When I was 16, I wanted a car that could fit all of my friends, which I absolutely got. It was a 78 Volvo. It was like literally bigger on the inside. That car is huge. Which worked well for me. It was yellow though, so my parents always knew where I was. My parents couldn't call me 90s, but I would come home and they're like, "Why were you in XYZ town?" It's like, "How did you know I was there?" I was the only one rolling around in a 78 yellow Volvo. My parents knew everywhere that I was because people are like, "Oh, we saw Emily." I was the only one. Like you can't mistake that car. I might have to wrap Travis's car some kind of way. The thing is, we can like track kids now with their phones. It's a little bit different. My parents had no idea where we were. It was probably good for our development. No idea where we were until other parents would rat on us and call and be like, "I saw Emily, blah, 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 blah." It's like, what do you need to know about it? That Volvo was a tank though. Loved that car. But you always knew exactly where I was because highly identifiable. There's a kid that goes to my son's school that has like a custom wrapped Barbie pink Bronco that's raised. It has like white what are the things on the wheels? Rims. It's gorgeous. I am not a huge car person. I want the sound system to be good. I want it to be quiet and to go fast. I am not a huge car person. I'm a comfort kind of a girl, but that car's pretty. Like real pretty. I need a picture of teenage EDB with that car. Maybe one stream. There are pictures. I have pictures. There's probably videos somewhere of us. I have vague memories of a video of us singing ABBA in the yellow Volvo somewhere that I don't know if I need to put on the internet. But that was kind of a lot of us had older cars when I was in high school. And like high school in the 90s and high school now are different. Like the bougie rich kids in high school would get like a brand new I don't know, Camry. Like the bougie kids weren't rolling to school in high-end BMWs, Mercedes, like luxury expensive vehicles. They were rolling to school in really nice new Jettas. Like, and we're like, "Oh my god, that Jetta is so cool." Said us. Said us. All right. I had a friend with a push button transmission Dodge Dart in high school. It was the fucking coolest thing ever. It was the coolest thing ever. It was just epic. It was absolutely epic. So yes, I love you guys sharing the cars in high school. All right. I saw somebody in the chat ask if I was a Taurus, sun and moon. I'm very Taurusy. All right. Is there any more we need to talk about with Murdaugh? Can we be done with him? Like yeet into the sun. Are we done with Alec Murdaugh? Oh no, we're not. I have one more thing I need to tell you about. Hold on. We have one more Murdaugh thing to do, and then we can move on because we have so many documents in Idaho. So many documents in Idaho. We need to talk about Murdaugh's insurance case real quick. Y'all remember the Nautilus insurance case where Murdaugh was getting real sassy and trying to add the Satterfields into the insurance case? Murdaugh's insurance company sued him for fraud, essentially saying, hey, we paid out this insurance claim because you defrauded us to pay the insurance claim and then you fucking stole it. So Murdaugh got his insurance to pay the Satterfields for Gloria Satterfield's death on his property, saying that the dogs tripped her. And then he said that was all a lie. And then he made it all up. And then he stole that $3+ million. So the Satterfields never got the insurance payout and he stole it. So insurance is suing him to get the $3 million back that he stole from them through fraud. He tried to pull the Satterfields into this case. Eric Bland, their lawyer, who also is on the Cup of Justice podcast and frequently comments about these cases on social media, was having literally none of it. Neither were the Lawnards. We were having none of it. We're like, stop it for the love. Just stop it. I went back and was digging into what's going on in that case now, given all of this, and found that the court denied that very, very swiftly and without much ceremony. Defendant Murdaugh, it says, had moved to compel the joinder of Tony Satterfield and Bryan Harriet as necessary parties under Rule 19A of the Federal Rules of Civil Procedure. Plaintiff has filed a response in opposition, asserting that Satterfield and Harriet are not necessary parties since they claim no interest in this litigation and Murdaugh does not face risk of double obligations. The court finds that Satterfield and Harriet are not necessary parties. Murdaugh's motion to compel joinder is denied. Satterfield and Harriet filed a surreply. Defendant Murdaugh filed a motion to strike the surreply because Satterfield and Harriet are not parties to the action. Defendant Murdaugh's motion to strike the surreply is granted. They're like, it's moot. So again, Murdaugh tried to drag them into another litigation where they would have to pay lawyers, saying, but you can't, like the litigation can't go forward if you're not here. And they're like, we never got any of the insurance money. We're not a part of this. The court agreed. Thank goodness. So that was dismissed. This case, it should be noted, is also in front of Judge Gergel. So the federal court is handling quite a lot of these cases and sees everything. So this judge has seen Murdaugh try to pull this shit over and over and over again. So I'm not surprised that Judge Gergel brought all the smoke for Alec Murdaugh yesterday and called him despicable, among other things. Done with him. Absolutely done with him. I think we're kind of done with him too until the appeal. We're done with him for a while because once we start the Karen Reed trial, the Karen Reed trial is going to be a couple, 5-ish weeks, I think. So we're gonna be a bit behind. We have other cases to catch up on. Murdaugh, you're not the main character anymore, sir. Like, you done. So aside from the appeal, I think we're kind of done with Murdaugh. Guys. Can we close it until we, we'll look at the appeal, but we're done. Murdaugh, you done. Yeet. Go to prison, Murdaugh. We'll check back in later. But it's gonna be a minute, sir. You've taken up quite a bit of our time. And we're done. We need to talk about Idaho. All right, y'all, grab your snacks. Maybe a glass of champagne, some water. I don't drink a lot when I travel because it dehydrates the voice so much. Grab your beverage of choice. We need to take a quick trip from South Carolina to Idaho. Buckle up, hands and feet inside the ride. And let's go. Oh, Idaho. So we covered the hearing from February 28th in March after we finished trial coverage of Hannah Gutierrez Reed. No relation to Karen Reed, spelled differently. And after we finished with the Gutierrez Rust Armorer trial, we circled back to catching up on what was going on in Idaho, including that court hearing. Part of the court hearing in Idaho was over whether or not the court would allow the defense to make and to hear a change of venue motion. The prosecution argued that motion was premature, that the change of venue motion can't really come up until you start assembling a veneer or a pool of jurors to come in and start asking them questions. And we saw this actually, talking about Murdaugh again, but we saw this really illuminated in the Murdaugh financial crimes case at the state level. They had sent out questionnaires for jurors to bring those jurors in to be questioned for the state financial crimes after the murder case that was getting ready to go to trial when he pled to the state crimes. And we started seeing in the defense motion about the responses on the jury questionnaires as they were compiling the veneer, that some of those responses indicated that a substantial amount of jurors had heard about the case. Not necessarily were biased one way or the other, didn't have preconceived notions. Some did, but had heard about Murdaugh in the case. The prosecution in Idaho argued that you can't really know if you need to change venue or move the trial somewhere else when you haven't even started pulling in jurors yet, because you can't know how exposed the jury pool is to this. And the case isn't really set to start. We don't have a trial date yet, but it's not going to start before the summer or at least late spring. What? The Blue Jays staring at me. Late spring 2025. So you not only are in a mostly college town, you're more than a year out from the trial date. What the jurors think now and what the jurors might think later is vastly different. So this is really the type of thing you need to hear closer in time to picking a jury, when you actually start picking a jury. I agree with the prosecution in this, because some of the people that live there now might not live there in the summer of 2025. You have people that will become 18 and become eligible jurors in the summer of 2025. Between now and then, who knows how many of them. You have people that might be home for the summer because you are in a college community. Like, a snapshot of the community now gives you no indication of what this community might look like when this trial starts. Also, the defense, I think, has argued quite a lot that this case is the trial of the century everybody wants theirs to be. And it has so much international media attention. Well, if it has that much attention, moving it from this location to that location in Idaho might not necessarily change anything. And I wonder if the defense is trying to force this because it seems that the defense has been sending out questionnaires to potential jurors in the area now to try to support their motion, which I don't think you can do. I've never seen it happen. So we're going to look at that together. The prosecution, when it, Your Honor, excuse me, the defense is contacting potential jurors. They can't do that to support their motion. So what is even happening? So today we have a fleet of motions over this issue. Is the defense, through their expert, contacting jurors or potential jurors in an improper way to support the motion that is too early for them to make? The judge is allowing them to make it, so he doesn't think it's too early. I think it's too early. I told you at the end of that hearing, I'm like, this judge loves to hear the lawyers talk it out. He likes to be part of the mix. I like Judge quite a lot, but he likes to be part of the mix. And I think that Judge, even when he hears this motion, is going to go, you know what? It is too early for this motion. But if the defense starts contacting jurors now, by the time you get to picking a jury pool, they're going to be like, I have heard of this case because you sent me a questionnaire to my home. So they might be proving the point with the things that they're doing now. So the prosecution's pissed. The defense is pissed. We have motions for a state's order prohibiting contact with prospective jurors, and we have a defense motion to rescind a court order. I'm going to try to keep these separate as we go through them, but we kind of need to go through them in chronological order because they build on each other. So we have two separate issues going on. State's motion for an order prohibiting contact with potential jurors and a defense motion to rescind a court order. Those are the two motions that we're working on. We have 10 filings to go through. Are you ready? I need lip gloss. I'm not done with my iced coffee. Law nerds, we have a lot of filings to get through. Let's go. The first motion is the state's temporary motion to seal their order. Don't worry, this is not all under seal. It starts getting unsealed real quick. So here we go. This is filed on March 22nd. This has happened since March 22nd. There were filings. There might be filings today, but there were filings as of yesterday that we're going to be covering. Oh, y'all, there's like 11,000 of you here. Do the YouTube things. I forget to ask. And if you're new here and you like court coverage, buckle up. We've got a trial coming. Join the app so you don't miss anything. Motion to temporarily seal the state's motion for order prohibiting contact with prospective jurors absent leave of the court pending hearing. Do you remember that there's a non-dissemination order in this case as well? Like, what is happening in Idaho? Come now, the state of Idaho, by and through the prosecuting attorney, and hereby moves the court pursuant to Idaho Court Administrative Rule 32G1 for a temporary order sealing the state's motion for order prohibiting contact with prospective jurors absent leave of the court, because release or disclosure would interfere with enforcement proceedings. Backside of paper. Deprive a person of a right to a fair trial or an impartial adjudication. Remember, the prosecution is also entitled to an impartial jury and the right to a fair trial, not just the defense. These rights go both ways. Constitute an unwarranted evasion of personal privacy. Could you imagine somebody like knocking on your door and be like, can we talk to you about this case? Constitute an unwarranted invasion of personal privacy. Disclose the identity of a confidential source. I don't know if that's an issue here. Disclose investigation techniques. These are the issues to seal. The court grants this motion to seal. So the state's motion is sealed. So we don't know what the state said other than the title of their motion. Later that same day, the court did this. This is March 22nd, 2024 at 17:27. The state's motion was filed at 2:27 p.m. God, do I need to switch between? What time is 17:27? Chat, help. I could ask my kid. He would know. His phone is in military time. His brain is in military time. I don't know. But the prosecution files at 2:27, so that would be 13:27. So 5:27 p.m. Thank you. 5:27 p.m. on a Friday. So a few hours after the state's filing. I mean, it makes it less confusing. You know it's AM or PM, right? Order prohibiting contact with prospective jurors until further order of the court. So the state files at 2:30. By 5:30, the court has made an order. On March 22nd, the state filed a sealed motion for an order prohibiting further contact with prospective jurors absent leave of court. The same day, defendant Bryan Kohberger filed an objection to the state's motion with the promise of a forthcoming affidavit and memorandum. So the defense was like, we object, but we're not there yet. We'll get there. Having reviewed the materials submitted, the court enters the following order. Both parties are prohibited from contacting potential jurors about this case, including via third parties, until further order of this court. A hearing on this issue will be held as soon as practicable. That hearing is not on the docket yet. Obi Devader said it's subtract 12 for PM. I appreciate that, but I can't do math in my head. I can't subtract 12. I can't do math I cannot do math in my head. I also don't have the benefit of being able to see things in my head because I have no mind's eye. The level of my neurodivergence is vast and wide, but I can't do math in my head, which is real frustrating when I play blackjack with the family because all of my family is very skilled at math in the head. Very, very skilled. So when I play blackjack with the family, I am at a stark disadvantage. I appreciate you guys trying to teach me military time. Old dogs can learn new tricks. All right. So state files under seal and says, yo, can you please tell people that they can't contact the jurors? Defense is like, objection, we'll tell you why in a minute. And the court's like, we're not doing this at all. None. So there we go. That's where we're at up to March 22nd. Let's see what the defense does next, shall we? Because that is a Friday. And then on the 26th, Monday, the defense files a number of motions. First, the defense asks the court to check themselves before they wreck themselves. And that's a 4-page motion that we're going to get into right now. This is filed March 26th at 11 a.m. from the defense. Motion to rescind order for failure to provide due process. The defense is big mad. Big mad. Big mad. Comes now Bryan Kohberger, Bryan through counsel of record, and moves the court to rescind the order issued March 22nd without providing due process. On March 22nd, late on a Friday afternoon, the state filed its motion to prevent contact with potential jurors. The motion included attachments. The late Friday afternoon filing was a strategic action by the state. The state was well aware of the survey taking place long before its late filing on March 22nd, 2024. Reading the state's filing. So the state files under seal, and now we know what the state basically said because the defense is putting it in this motion that's not under seal. Good, we're curious. Reading the state's motion, it is clear that the state was aware of the survey process by March 8th. Oh. The state reached out to defense counsel on March 19th and scheduled a meeting for March 21st. By the time the parties met on March 21st, the state had at least one transcript of the survey and knew the questions that were asked. At no time during the 13 days between March 8th and March 21st did the state determine an emergency existed that must be brought to the court's attention. Well, by the 22nd, they did. When they saw the questions, perhaps. On March 22nd, counsel for the state and defense met. The defense provided a CV for its expert and discussed the survey and its content. The defense informed the state surveys such as these were common practice when you're picking a jury. Tell me more about this. I have not seen this done, but tell me more about this before picking a jury. I have seen these surveys done as a veneer's being picked. I have seen both sides come together with the court and say, what questions are we asking the jurors? And then the court is the one reaching out. But I have not seen this. Maybe it is common practice. I have questions. I've only seen the court sending this out, not the defense. The state could have easily and likely did find that this very expert did similar survey work in Idaho on at least 2 other occasions. Don't worry, we're going to look at the CV. Want to bet they're Vallow Daybell cases? Surveys such as these meet the standard of care required of the defense in a capital case, yet the state told the defense it wanted to tell the judge about this. Yeah, I bet they did. Why is... I'm trying to see why my weather is beeping. The defense agreed to attend an on-the-record in-chambers meeting to discuss the defense work being done. The state chose not to wait. Okay. Counsel asked the state to refrain from giving the attachments to the court prior to a meeting where the defense could be heard because the court may take an action, thus prohibiting Kohberger an opportunity to be heard. That's exactly what the court did. Unfortunately, through its letter writing to the court, the state has achieved previous action from the court without Kohberger receiving due process. The state knew what it was doing when it filed a late afternoon motion with attachments. The state was trying to stop you. So they're saying the state strategically filed late on a Friday to put an end to the defense's surveying of potential jurors. They might well have. Mr. Kohberger quickly filed an objection and stated further information would be coming. The court issued an order halting the defense work without giving Kohberger an opportunity to be heard. This is a violation of Kohberger's constitutional rights pursuant to the 14th Amendment. They list out the definition of the due process right from State v. Blair. The right to procedural due process requires that when a constitutionally protected interest is at stake, a person involved in the judicial process be given meaningful notice and meaningful opportunity to be heard. The opportunity to be heard must occur at a meaningful time and in a meaningful manner. Well, you know, if you're asking for forgiveness, not permission, sometimes the court's going to be like, no. I imagine that Judge is going to be like, these surveys should have been run through the court before they ever went out. I imagine that's what Judge is going to do based on everything we've seen Judge do. Could I be wrong? Absolutely could. Absolutely could. Mary Herbie in the chat said, didn't the court know they were doing this? From all of these filings, I don't think the court knew they were doing this. The court knew they were going to have an expert talk about exposure or potential media exposure. I don't think Judge knew that they were surveying people to support their motion. I don't think he knew that. Because when the prosecution said, we want to tell the court, the defense did not respond in here. The court already knows. If that was true, Ann Taylor would have said, and the court was previously alerted to this, blah, 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 blah. That's not what's in this motion. What's in this motion is the state wanted to tell the court. I think they're saying the state wanted to tattle. The state be snitching. It's the state. What do you expect? So it doesn't indicate in here anywhere that the court knew what the defense was doing. The defense very clearly lined out that they believe the state knew as of March 8th. The defense is completely silent as to the court. And if the state knew that the court knew, it would be in here. And if Ann Taylor had already told the court, she would say it in this motion. Let's get to the end of the motion. Maybe it's in here later. Keep reading. But I think it would have been the prosecution knew the state was aware of the survey process by March 8th. I think it would also be in here. And the court was aware as of it's silent as to that. So I don't think the court knew. And the swiftness of the court's action is giving, what the fuck are you doing? The opportunity to be heard must be at a meaningful time and in a meaningful manner to satisfy the due process requirement. Case law at a bare minimum, quote, there must be some process to ensure that the individual is not arbitrarily deprived of his rights in violation of state or federal constitutions. I think there are ways to remedy this. And the court said, I am stopping this until we can have a hearing. I don't think we have a due process violation. The defense clearly sees it differently. I am a former prosecutor. Defense attorneys may see this differently. But I think the court is saying, stop. Collaborate and listen. I think the court is saying stop until we have a hearing. None of this is going on. This is unusual. Whenever you do anything weird, the court's going to want to know this is weird. This is not regular course of business for cases. For the court to take action without ensuring Kohberger had an opportunity to be heard stops the defense from preparing to meet its deadline for filings in support of its motion for change of venue. That deadline can be pushed, is the remedy here. The remedy here is have a hearing about the surveys and then push the deadline on that. That's what's going to happen. There's not even a trial date set. Like, this is not that big of a deal. The order damages Kohberger in carrying out his work to ensure a properly prepared defense and ensuring a fair trial by an impartial jury. The order also prejudices the state because the survey work is complete for Latah County, but is not complete for other counties for comparison. Oh, they've already surveyed all of Latah County. Isn't that interesting? No court order should have been entered without procedural due process or unless the parties stipulate. Your Honor, don't stop me now. Oh, the ADHD is just popping with song lyrics today. Your Honor, don't stop me now. All right, so then the defense files a memorandum in support of their objection to the state's motion for an order prohibiting contact with the jurors. So now we're going back to the other question. The defense just asked the court to withdraw their order. Your Honor, can you overrule yourself? And now the defense is asking for the court to not grant the order that the court already granted. All right? We're going to learn a lot more information because the defense didn't file this under seal. The prosecution filed theirs under seal, so we don't know what they said. The defense did not process this under seal. Memorandum in support of objection to the state's motion for order prohibiting contact with prospective jurors absent leave of court. Bryan Kohberger, lawyers. Telephonic surveys. Oh, it's worse than written. Telephonic surveys to explore the media stories the juror population has been exposed to is not a violation of this court's revised order issued June 23rd, 2023. That would be the non-dissemination, aka gag order. The state has alleged the defense has violated this court's revised order. Specifically, the state alleges the defense has violated the prohibition on discussing, quote, the identity or nature of evidence expected to be presented at trial or any sentence phase of the proceedings. The order also prohibits the disclosure of, quote, any information a lawyer knows or reasonably should know is likely to be inadmissible evidence at trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. The defense is aware of these prohibitions. After all, the defense wrote the original order upon which it is based. Your Honor, we know what it says. We wrote it. The defense is aware of these prohibitions. After all, they wrote the original order. The state, however, misunderstands the prohibition in this respect. And they don't even know, Your Honor. The defense is not disclosing information. The defense is asking prospective jurors in the county of Latah as to what information they are aware of that was previously, quote unquote, disclosed via the press. Further, the revised order for non-dissemination allows for counsel to ask questions of the public to do its work. That is exactly what happened. Is it though? Kohberger, in his preparation for change of venue, is mindful of what the court must consider and the available means to obtain information for this evidentiary hearing, which is why these hearings don't happen until a survey of the veneer is already underway. That's what the state argued. The state's motion and court's order intrudes on one of the ways the defense will seek to establish prejudice pursuant to Idaho Court Rules 21. Or is it creating the situation? Like, I feel like at some point we're a snake eating its tail right now. Like, is this creating the issue? When somebody calls you and starts asking you questions, is that different than receiving a written juror questionnaire that the defense, the court, and the prosecution have worked on together? Isn't this creating more of a situation to move this case? The state could never get away with this. State versus Haddon outlines relevant factors a court must consider when taking up a change of venue motion prior to attempting to seat a jury. Extensive publicity, accuracy of publicity, the size of the community from which the jury can be drawn. The court created a bit of this problem by saying, let's see what the defense has to present over a year out from the trial. The Haddon court is referencing the size of the county as being small, said, quote, however, this fact alone does not require the presumption of prejudice, nor would such a rule be practicable given the relatively rural nature of many of Idaho's counties. The Haddon court said a party challenging venue must bring more than the size of the community. Certainly, pervasive media coverage that continues to this day is a factor and will be discussed in a later filing. The focus here is on critical survey work, obtaining information to support the change of venue motion by establishing quote unquote more in addition to the size of the community. This important work will establish the reasonable probability of prejudice. When I saw that the defense was bringing in an expert, here is what I thought would happen as we were watching that hearing go down, that the expert would be conducting analysis of how many stories have been done, how many YouTube videos have been done, how many accounts are talking about it on Twitter, how many impressions Bryan Kohberger's name in this case have on TikTok. I assumed it would be more akin with the analysis of internet activity that we saw in like the Deppie Heard case. Remember when Amber Heard's team introduced all of the analytics regarding hashtag Amber Turd? I sure do. I thought we were going to get an analysis akin to that. This is the activity on social media. This is the media activity. This is the, number of front page stories of papers that get delivered to Latah County, that sort of thing. But no, they were making phone calls. To provide that quote unquote more, the defense hired Dr. Bryan Edelman, owner of Trial Innovations. What are we innovating, Mr. Edelman? Dr. Edelman is an experienced doctor of social psychology. Fascinating field. Social psychology absolutely fascinates me. With additional educational achievement and experience in statistical surveys. It likely will help to understand how surveys are done in cases such as this. Oh yes, please tell us. Please tell us everything. The survey to be valid must be done by a random selection of contacts. The number of surveys are small, but enough to see trends that are attributable to a larger population. See the declaration of Dr. Edelman attached as Exhibit A. Oh, we're going through all of this. All. The question in the survey seek limited but important information. To qualify, the surveyor first asks if the person reached is an adult and a resident of the county. Then the survey continues with opinion, exposure, and connection to the case questions. Can we add a question for how many times my name came up? I'm curious. Can we add a whole list of content creators? I want to know. Emily, main character syndrome? I mean, a little bit. Sometimes I'm a content creator. What do you expect? I am being facetious. Dr. Edelman, after extensive research of the media coverage in this case and with approval of counsel, designed the media influence questions around statements that have been in the media. You can find a statement for anything that's been in the media about this case, depending on where you look. What do you consider media? Are we getting to like randoms on Twitter? No disparagement to randoms on Twitter, but like you can find a statement in the media that says basically anything about this case. What are you saying? As counsel for the state wrote in their motion, which is under seal, many of the media influence questions are not factually correct. That is exactly the point. Carla, I heard this, and I asked you guys about it last night when we were recording the members only podcast. I heard that I was mentioned during the Chad Daybell jury selection that like when people talk about what kind of media they consume, that I came up. Off topic question. Does Emily have a new Starbucks cup? Mia, no, I do not. It is an old Starbucks cup. It is glass. And that's where I put my iced coffee because I don't really have any, I didn't have anywhere to put it. I wanted the cold foam on the top. So I didn't want to drink it through a straw. It was a whole decision-making process. So we ended up with the glass Starbucks cup. So far, I like it. This is what the Hayden court said in relation to extensive media coverage. Non-factual media dissemination is more harmful. I mean, how do we know what's factual? So much is sealed in this case, we don't know what's factual and not factual. It would be of little use to this court to know that there was a deluge of unobjectionable media coverage. The only way for the court to have any way of understanding what the parties would face with a juror from Latah County is to know what they are being exposed to. It's the internet. It's not cordoned off county by county. The only way for this court to have any way to understand what the parties would face with a juror from the county is to know what they're being exposed to. You can do that without questioning them, though, by doing a survey of what's in the media. I think they're trying to end run the fact that the judge would go, but how do we know that the jurors have seen that? Well, you ask them in the juror questionnaire when you start seating a jury. In a year. Kelsey Hart asked in the chat, oh no, is me watching Emily going to get me cut from jury duty? Only if it's specifically about a case that I've covered. Generally, no, it should not. Like understanding the legal, lawyers don't just get cut from jury duty because they have legal knowledge. Having legal knowledge is not the issue. Knowing too much about a certain case is maybe an issue. Like on this case, if you've watched every single minute of every single motion, they might have some questions. As Dr. Edelman can testify, that is the sort of work parties do in these cases. Your Honor, it's just done. This is what we do. It may be new to some in the county, but it is... These prosecutors just don't know, Your Honor. They just don't know. It may be new to some in the county, but it is still the industry standard, professional, and ethical way to do this work. I feel like you have to talk to the court about doing this first, though. But, Your Honor, it's just everybody's doing it, Your Honor. It's judge. This is just the way things are. This is what everybody does. We just call people up and be like, yo, have you heard of Bryan Kohberger? There is no realistic possibility that this will affect the jury selection in the county. Ma'am. Ma'am. Have you been exposed to media coverage of this case? Well, not until I got a phone call asking me about all these random headlines, and now I've got questions. There is no realistic possibility that this will affect the jury selection in the county. I don't know if I agree. I need to see the questions first. The problems with this county are not of the defense's making. They are what the defense wishes to expose for the court. Okay. You can't say they are not zealous advocates. The state's motion is filed against a backdrop of Kohberger preparing for his motion to change venue. The state objected to the court scheduling a change of venue hearing, and now through this motion is thwarting the defense's preparation for the motion. They objected to it coming now. They said that it's premature. I realize what we've just done there. We're going to keep moving. I agree with the state. This motion doesn't normally happen until you are underway in jury selection, which I understand is a fucking logistical nightmare in a case that is expected to last at least 3 months. The defense has said that they have over 400 witnesses. This is going to be an extensive trial. If you move the venue in 2025, you probably won't find another courtroom until 2026. I understand all of that. But you're kind of in a cart horse situation. They say that the state is thwarting the defense's preparation for the motion, or the defense calling up jurors and asking them if they've heard of these headlines is exactly proving their point because they're trying to prove their point. The state knows counsel for Kohberger did not violate the revised non-dissemination order. The state and counsel met the day before the state filed its motion to discuss the content of the survey. That's probably what they found objectionable, though, is the content of the survey. The state was informed that these types of surveys are not an anomaly. Don't they normally have court permission? Like, why are we silent on whether there is normally court permission? Silent from it. Christina said regarding Jelly Roll, I used to live down the street from Billy Ray Cyrus. He used to ride his very loud motorcycle down the road at 3 a.m. We all hated him. Lol. That kind of noise would make me angry as well. I had a neighbor who would sit outside on his like rooftop deck with an amp and a guitar at like 1 a.m. But that rooftop faced the room where my kids were sleeping. And we have a very neurodivergent household. All of us have sound quirks. So it was just, do we need an amp? Like, do we need an amp? Seriously? An amp on the rooftop after midnight in California where houses are all like this close? Like, why an amp? Like, if it was acoustic, I would probably be like, You know what I have found since moving a little bit more into the country is that more land makes for great neighbors. I enjoy seeing my neighbors. We all have a bit more space. You know, just having more land, just a little bit more of a buffer zone, all of us are happier with each other because we all just have a little bit more space. I mean, he was a good guitar player, but it's just like place and time, my guy. However, the state filed its motion anyway. The state's motion should be denied. The order prohibiting future contact with prospective jurors should be withdrawn. Your Honor, but things. Declaration of Bryan Edelman, PhD. I'm fascinated. I mean, I will also say that more space makes people happier in a lot of ways. Dual sinks, by the way, is required for the longevity of a healthy marriage, I think. My opinion. Dual sinks. Dual sinks. Cannot be underestimated. Sometimes separate bathrooms. Sometimes separate bedrooms. It just depends on who snores. But separate sinks go a long way. Separate bathrooms sometimes go a long way. Trust me, when we moved from 900 square feet in California to substantially more than that, having one toilet per person in our household has made a huge difference in the world. A huge difference in the world, especially with kids. All right. Moving on. Introduction. I am the co-founder of Trial Innovations, Inc., a national full-service jury research firm. I have worked as a trial consultant for 20 years and have conducted pretrial and post-trial research in both criminal and civil cases across the country. I have been retained as an expert in over 70 high-profile cases to access the impact of pretrial publicity on the fairness of trial proceedings, including Idaho versus Renfro, Idaho versus Rodriguez, Colorado versus Holmes, United States versus Robert Bowers, State of Florida versus Nicholas Cruz, and United States versus David DuPape. Counsel for the defendant in this case retained me to research and evaluate, one, whether the existence of prejudicial pretrial publicity surrounding the killing of 4 students attending the University of Idaho in Moscow, the community panic that ensued, and the search for the suspect, which ended with Bryan Kohberger's arrest. Oh, whether there was extensive publicity surrounding that. Even the way they worded it, even the way they worded it, shows you which way they're looking through the lens here. But he has worked on serious cases. 2, determine if the media coverage has impacted the defendant's ability to obtain a fair and impartial jury in the county. 3, whether community residents in alternate venues exhibited similar bias. And 4, based on the findings, recommend appropriate remedial measures, for example, a change of venue to protect Kohberger's ability to be tried by a fair and impartial jury. As a part of my analysis, I evaluated relevant newsprint, television, social media coverage surrounding these events and conducted a community attitude survey of 400 residents in the county. What is the population of Latah County, Idaho? 40,000. So the county has a population of 40,000. They, according to Google, and they interviewed 400. Interesting. Comparison surveys in alternative venues have yet to be completed. These surveys were designed to assess case recognition, familiarity with prejudicial media content, and bias. I mean, I think that case recognition is probably high. But yes, like a 1% sample size. Qualifications, education, and experience. His CV is listed below. Let's see. Undergrad, received an MA and PhD in social psychology from the University of Nevada, Reno, and LLM, which is generally a legal master's degree, not a practicing legal degree, like more of a theoretical degree, from the University of Kent in the UK. Graduate studies have provided me with a broad foundation in both qualitative and quantitative research methodologies, as well as statistics. Do you call yourself doctor? Oh, wait, you do. You titled yourself doctor for sure, because PhD. The social psychology program at the University of Nevada is unique in that it is one of the few in the country that has an emphasis on the application of social psychology theory to the legal arena. Interesting. During my studies, I specialized in juror-related issues and examined how attitudes, race, stereotypes, pretrial publicity, and other factors influence juror and jury decision-making. In this regard, I took coursework addressing topics associated with the change of venue motions, the impact of pretrial publicity on jurors' ability to be fair and impartial, steps necessary to conduct a change of venue analysis. The university's association with the National Judicial College and other government agencies also afforded the opportunity to conduct research within the public defender, district attorney, court services, and the judiciary and other institutions in Washoe County, Nevada. And then it goes through research experience. We're not going to go through all of that. Jury research experience. Began working as a trial consultant in 1998, co-founded Trial Innovations in 2010, worked on hundreds of criminal and civil cases across the country, consulted in the courtroom and assisted jury selection in more than 100 cases, has been invited to conduct MCLE, which is continuing legal education, courses related to jury selection by the public defender, alternate public defender, district attorney in California, Nevada, and New Mexico. I would be interested in a CLE on that. Like, I would take that CLE. I would absolutely take that CLE. I would be curious. I've also served as a guest lecturer at the University of Santa Cruz, St. Mary's College, and Stanford Law School. My opinion of Stanford Law School has changed in recent years. Venue experience. As a graduate student, I was trained by Dr. Ronald Dillihay. Damn it. My kid took my pickle, so I cannot pickle appropriately, and I am... Oh. Now I'm contemplating whether I need to get up and get the pickle, because Dillihay, it just needs to happen. And Dr. Bronson, two of the leading experts in the country on venue and pretrial publicity. Over the years, I've had an opportunity to work with Dr. Bronson on a number of change of venue studies. I've worked on change of venue issues in several different capacities. Fantastic. I would absolutely attend this CLE. You guys are like, get the pickle. I see you all. You're like, Emily, just get the pickle. I feel like we can't move on until we have the pickle. Because StreamYard allows me to leave you with some delightful music, I'm going to leave you with some delightful music. Give me 1 second. That's not my favorite one. I like that one better. All right. Delightful music. 30 seconds. We'll grab the pickle. The Longhorns have demanded the pickle, and StreamYard allows us to have music. Thank you, StreamYard. This is why I only stream on StreamYard. A, StreamYard is the best. B, StreamYard is the best. And C, StreamYard has, old music where we can vibe. All right. Thank you, StreamYard, for the vibes. Well, we grabbed the pickle. Look, I think did we end up with Pickle's Cage? I don't remember where we ended up with the pickle name. There was a pickle name that came out of the Hannah Gutierrez trial, and I think I forgot what it was. But we needed the pickle. We needed the pickle because I'm sorry, Dr. Ronald Dillihay. I'm sure you are eminently well qualified and quite intelligent and well hydrated, but we can't not. Chat, that's right.
It was Gorilla Grip Pickle Pal. Yes. How? Lest I forget.
Look, my brain is tired. But it was Gorilla Grip Pickle Pal. And how could I forget? I am embarrassed, but it was Gorilla Grip Pickle Pal for now. We'll see what happens, but we did opt to change it every trial. So we will see what happens. We will see what happens. All right. That's for my kids stealing the pickle. Thank you, Vincent Van Goat. Vincent Van Goat is named, the name stays, but Gorilla Grip Pickle Pal's name changes per trial. So, we did all the things. Okay. Let's get back to this doctor's experience. We might need a goat emoji for the members. The pickle works. Mia Moo has the gorilla and the pickle. It's just perfect. Absolute perfection. Absolute perfection, chat. Do you keep track of the pickles names? No, the chat does. The chat is bae. The chat is like the law nerd hive mind. The chat knows. The chat knows everything. The chat is wise. So the chat knows. That's what we do. Okay, let's get back to who's talking to these jurors. Let's see. The influence of attitudes on cognition. Look, I would love to dive into this area of study more. Fascinated. Absolutely fascinated. I'm here for all of it. I would take this CLE. Sir, I will pay hands down for this CLE. I want to know all the things. Super curious. However, for today's purposes, I still think maybe the permission of the court is needed. Let's see. The influence of attitudes on cognition. There is a substantial body of literature documenting the impact of attitudes on information processing. Surprises me not. Attitudes have been shown to have an impact on selective attention, the evaluation of new information, memory recall, and behavior. This research provides insight into how media coverage may lead to juror bias. Pretrial publicity can have a prejudicial effect on jurors through its impact on the formation of attitudes and beliefs that they bring into the courtroom. Attitudes are not isolated entities, but are often linked to other memories, experiences, attitudes, and beliefs. It can be hard to keep an open mind. It can. But I think a lot of you exhibit it really well. Think back to one of the trials that I've covered and how you felt going in and how you felt at the end. I saw a stark stark shift. Hold on, we're going to sidebar for a minute. I saw a stark shift in attitude in the Gwyneth Paltrow trial. Stark. People went in with kind of like, I mean, fuck Gwyneth Paltrow and Goop and whatever. She ran into that dude. This is ridiculous. Like, celebrities. Midway through that trial, everybody was like, bro, what are you doing? Why did you hit Gwyneth Paltrow on the ski slope? People went in with very, very negative attitudes towards Gwyneth and like negative attitudes towards her as a person with no information about the case. Just like, yeah, but Gwyneth. And I saw the shift as the evidence went on. And that's when people had no information about the case. When people had some information about the case, they still went in pretty much anti-Gwyneth. But then they came around to, okay, I mean, I don't love Gwyneth, but I also don't think she hit that dude on the ski slope. Like, people were able to keep an open mind despite not having a great opinion of Gwyneth. I think it shows that people, when they are aware of how they feel about something, are able to keep an open mind and are able to take in new information and change their mind. Some can't, but I also think most people are able to see that they can't and are honest about that. Truly. And I think we saw that in Depp Heard as well. If you watch my early coverage of Heard, and Law Nerds, you know this, the Heard stands don't, but the Law Nerds do. If you watch the early coverage, most of my early coverages, I don't know how Johnny Depp is going to win this case. I mean, go off, bring this case to trial if you want to. I don't know what you're going to do. I don't know how you're going to win this case. I had only looked at the filings. I had never watched any of the deposition footage. And then the deposition footage, and then the audio recordings, and then the testimony in court. And then I went, welp, this is why you decided to bring it to trial. It's not a legally easy case, but I can see why you chose to bring it to trial. My perception of the case shifted as evidence came in. Because I started with, why are you doing this? I realize you have fuck you money, but why are you doing this? And then as the information came in, I went, oh, there's a lot there. So opinions and initial impressions can and do change. And we saw it at scale with Paltrow, 50,000 plus people, with Depp, hundreds of thousands of people. We had over 370,000 people at verdict, and a lot of them changed their mind mid-trial. And a lot of you questioned yourself because a lot of us came into this, I think, with a natural bias pro Amber Heard. Like, I don't want to believe that she would lie about this stuff. Like, there was a dissonance between our own perceptions of the world, our own life experiences, and being like, I really don't see how she could lie about this. There was a lot of that when you looked at the hundreds of thousands of people on stream with that. And then that started to shift as the evidence came in. But I think everybody acknowledged that they have a bit of, I am inclined to believe her over him going into this. But I want to listen to the evidence and I want to see what happens. And as we listened to the evidence and saw what happened, then it was it is shift. And I saw on stream hundreds of thousands of opinions change. And so I understand that there is research here, but I also know what I've witnessed in real time being with y'all gavel to gavel through these trials. A lot of you came in, and some of you might still be there. A lot of you came into Murdaugh being like, I can't wrap my mind around that he might have done this to his wife and son. Like, I can't wrap my mind around somebody doing this. It is unthinkable. And then as the evidence went on, it was like oh, yeah. I've seen people change their minds. Some won't. But those are the jurors that are gonna get weeded out anyway. Because there are people who will say, I can't change my mind on this. I have an opinion, I'm not changing my mind. Changing your mind's not a bad thing. Taking in new information and being able to evaluate where you came in from and say, but I'm open to hearing what you present to me, and I can be intellectually honest enough to change my mind when presented with new information, is just the sign of being a mature human. And the law nerds do it really well. I just think sometimes, especially when they're talking about jurors or when the media is talking down to all of us like we're idiots, that humans are not as dumb on the whole as people want to make us out to be. And though there is some of that, sure, but I don't think that as the whole, that's the case. I think people can change their minds. But that's, again, just what I've seen from talking through a lot of trials now with tens of thousands, if not more, folks on the internet. I watch it change as we go through the trial, which I'm really interested to see where we're at with Sarah Boone after opening statements. Not Sarah Boone, with Karen Reed, where we're at after opening statements and where we go forward. I'm real interested to see it. So, Marissa, I agree with you. 100%. Marissa said, I will not change my mind about Pluto being a planet. Look, justice for Pluto. I agree. I disagree. How can you just revoke planetary status? So I agree with you. I refuse to change my mind. Science be damned. Pluto's a planet. I'm with you. But I think when we go into trials, a lot of people are willing to have an open mind. So, the influence of attitudes on cognition, footnote 2. Cognition is a term referring to the mental process involved in gaining knowledge and comprehension, including thinking, knowing, remembering, judging, and problem solving. Pretrial publicity can have a prejudicial effect on jurors through its impact on the formation of attitudes and beliefs. These links can create large networks of attitudes which are resistant to change. The links between attitudes strengthen with repeated activation. This is why people end up in like echo chamber loops. There's times now on social media. I don't know which device is talking to me, but stop it. There are times on social media where you will see this play out, where people don't want to have a nuanced conversation. They just want to reinforce their own beliefs. And it's getting easier and easier and easier to just find things that reinforce your own beliefs, because you will see celebrities called out for, God, I didn't think we'd be ranting about this today. Sorry. Not sorry? I don't know yet. Maybe I'm sorry. I'll decide later. But you'll see like celebrities called out for who they're following on social media. If it's like, well, why are you following that person? Or why did you listen to this podcast? Or why did you do that? Sometimes it is healthy for us to engage in listening to things we don't necessarily agree with, because the only way we know our own beliefs and we can test our own values and thoughts is by listening to other values and thoughts, listening to other perspectives. And we've gotten into a place where listening to other perspectives is somehow a really bad thing. And I don't understand that at all. And there are times when I look at people wanting people to not have conversations online. Not the law nerds, y'all know this. But like you XYZ can't have a conversation with that person because they think whatever. I think when we get into you can't have a conversation, it's dangerous. I might not want to have a conversation, but I'm not going to tell somebody else not to have that conversation. I think conversations are how we learn. And I think conversations are how we grow. And I think conversations are how we understand each other as humans better. I mean, we learn through really storytelling. And if you're like, I'm not going to listen to this person's story because I might not agree with them, then you'll never really understand your own position because you won't understand the other side, and you have to be able to argue the other side. My teen and I have been talking about this so much lately because he had to do a project, and he and his team in debate for it might have been English. I'm not really sure I don't remember exactly which class it was for, but they picked a difficult side of the debate on censorship because his team was like, we want to take the challenge to argue pro censorship, which is a difficult sometimes perspective to come from. And so we talked through it a lot where he was like, it's kind of difficult to wrap my head around something that I don't agree with and argue it. And I'm like, right. And it's a good thing to grow, not just a broader worldview, but if you come at the other side from a place of understanding, you're going to be more effective. This is something that you have to do as a lawyer. Like you have to be able to see where the other side is coming from so that you can head them off at the pass. That's the only way you're going to win. It's not different than sports ball. You watch tape on other teams so you know how to overcome their defenses. Listening to other points of view is the same. It's no different than knowing the defense. You have to hear the perspectives on the other side. It doesn't mean you have to listen to people rant at you with hate. It doesn't. But you need to expand your points of view, which is what I hate about watching social media be like, you can't listen to this person's podcast, or you shouldn't, follow that person on social media. There's people I follow on social media, not because I agree with them, because I want to see what the fuck they're saying. That's all. So it's really interesting. The law nerds are here to have nuanced conversation and look for the other side of an opinion. I hate seeing it be shut down. But I absolutely agree with this too. In the chat, Toya said that only works with people who also want to debate. Yes. It cannot exist in a space where people want to just shut down conversation by name calling and ad hominem attacks. It can't exist there, which is why I suggest, even if you don't want to get into a debate with people, and there's times you can't get into a debate with people because they're just going to attack you. And that's fair. But listening to other conversations is very interesting. And there's times you can listen to other conversations without having to engage with those conversations, because not everybody, those are two separate things, right? Listening to other viewpoints and engaging in conversations are two different things. But the chat has pointed out very well that has to be an engagement of good faith to have a conversation, and not everyone will engage in good faith. But if you choose people to listen to that you don't agree with, you can do it kind of one step removed because social media exists. Luby Lou Online said, my favorite saying is, no one is listening if everyone is shouting. It is an excellent point of view. An excellent point of view. And it's one of the things that really makes me sad is when nuance gets lost, when conversation gets lost, when it's like, you can't say that, you can't say this, you can't ask that question. It causes me grave concern, because why can't we ask questions? Like, if you have an answer, why can't I ask a question? And then you have an answer, and then I learn, and then you learn, and then we all learn together by asking questions, which is what I love about the law nerds so much. We're here, we're like, we can ask questions. It doesn't mean we agree or disagree. It might just mean that we would like to learn something. Like, can you explain to me? I'll understand better. You'll understand better. We'll all understand better. But social media is not a place for nuance. Short, quippy apps with characters are not for nuance, and people make money on that app. The Bird one particularly. People make money on that app by rage baiting and fear baiting, because that's the rage is where the engagement is, because that's where you get people just fighting in the threads, and it's hugely threaded, and there's no discussion. There's no nuance to it. And I'm so fucking over it. I rather just have a conversation. And that's why we're here. Let's get back to this doctor's perspective on cognition. Look at us. We've gotten to cognition. He's saying the links between attitudes strengthen with repeated activation. This is why echo chambers are a problem. As these links strengthen, the probability increases that the attitudes and underlying beliefs will be consistent with one another and brought to the awareness simultaneously. Attitudes that are strongly linked to one another are more easily accessible in memory and more likely to be automatically activated with exposure to the attitude object. Attitudes can be activated automatically without any conscious internal processing. This is more likely to occur when an attitude has been repeatedly activated in the past. Footnote 3, linking to the psychology of attitudes. You guys, we might end up with a reading list from this interesting breakdown of cognition. When media coverage surrounding a case is broad, extensive, and redundant, strong links between relevant attitudes and beliefs begin to form. If the pretrial publicity creates links between case details, attitudes, and beliefs, there's barely any case details here. But I digress. Between case details, attitudes, and beliefs over the course of a trial, these attitudes are likely to be automatically activated at a subconscious level. As described below, the network of linked attitudes can have an impact on a juror's attention to an evaluation of the evidence and arguments presented in court. Excuse me. As the network of linked attitudes grows and strengthens, specific attitudes become resistant to change because change requires revisions to other attitudes and beliefs within the network. Resistance to well-established attitudes has been shown to lead to biased information processing. When attitudes are strong, there is a tendency to favor arguments and information in support of those attitudes over arguments that may disprove them. The acceptance of a counter-argument can create cognitive dissonance. Footnote 4. Oh, the Blue Jay is just on one today. Sir. Cognitive dissonance is an uncomfortable feeling caused by holding two contradictory beliefs simultaneously. People have a motivational drive to reduce dissonance by changing their attitudes, beliefs, and behaviors, or by justifying or rationalizing them. Law school broke my brain in this way. I'm very happy to be able to see the disconnect and evaluate it. But I also went to law school to really learn to think differently and take my own beliefs, if you will, out of it and evaluate the thing, which is why lawyers can come across very black and white. There's times that lawyers can come across way harsh, like that was way harsh, Ty. You guys know what that response is to. But lawyers can come across way harsh because the feelings and emotions are out of it, their own opinions out of it, and they are just like in a very logical way, logically evaluating the facts on both sides. So it's often that lawyers will communicate in a very kind of black and white way that does not account for emotional sensitivity. And it's something that there are times I still struggle with, to not get so deep into the lawyerness that we're not addressing the emotional impact or the values of a thing. Chad, I see you. So lawyers can be very, very seemingly harsh when evaluating these things because there is no emotion in it. And they've taken that all out. So I try very much to blend the two. I don't always succeed, but I try very much to blend the two and acknowledge the emotion of a thing before diving in to the processing of a thing, because I find that very helpful. But when I am in conversation with other lawyers, that quickly goes right back out the window. And it is just to the very, very cold logic. So, all right, continuing on. Attitudes can have an impact on attention and recall. Research has shown that information that supports a pre-existing attitude is easier to learn, more accurately retained, and easier to recall. The links formed between attitudinal support information and pre-existing attitudes are stronger than those formed between counter-arguments and pre-existing attitudes. As a result, the latter is more difficult to retrieve from memory. Further, there is a tendency to produce new beliefs which support pre-existing attitudes and suppress those that run counter to such attitudes. In sum, when a venue is exposed to prejudicial media coverage surrounding a crime, there is a risk that potential jurors will develop a large network of linked attitudes and beliefs relating to the victim, the defendant, and the crime. These linked attitudes include opinions about the guilt of the defendant, appropriate sentence and evaluations of the evidence presented through the media. I don't think there's been any evidence through the media here. When the links between attitudes are strong, they can be activated at a subconscious level and have an impact on jurors' evaluation of the evidence and arguments presented at trial. He is going to keep going on the scientific studies of all of this. I am just looking at the time and knowing that we need to move on because there were lots and lots of things, but this motion is available. This is the defense's motion because we've got 21 pages. We were on page 7. This is the defense's motion. It's available on the Idaho website publicly if you want to go back through his breakdown of attitudes, shifting attitudes, of the footnotes citing his research. I find it fascinating. I will read back through this later. I find it absolutely fascinating. Absolutely fascinating. And we can post the link from the Idaho or to the Idaho case website if you guys want to pull this up for yourself to go through all of these different studies from, well, a lot of these look like the 70s and the 80s. Because I think it is, I think it's very interesting. Let's see. I want to see if he gets into the questions that were asked, but quite a lot of breakdown. So let's see. Telephone survey. This is what I wanted to get to. I'm fascinated. I'm fascinated by the rest of it. I'm like, Emily, you have to move on or we're going to be here for 7 hours. Telephone survey. A telephone survey of 400 residents was conducted in Latah County. The sample size of 400 was calculated via a power analysis. Ooh, what's a power analysis? That sounds fun. Via a power analysis to reach an industry standard 95% confidence interval of plus or minus 5% using the most conservative response distribution, 50%. Comparison surveys were planned in 2 alternative counties to assess any potential bias found in Latah County carried over to the rest of the state. The survey instrument used in this case adheres to industry standards established by the American Association of Public Opinion Research. I had no idea. The change of venue survey professional code established by the American Society of Trial Consultants. The survey instrument topics of focus and questions were constructed after more than 269 articles that referenced the murders in the Moscow Pullman Daily News, Idaho Argonaut, and Spokesman Review. So they focused on local media. Steps were taken regarding the structure and flow of the instrument and design of the questions to mitigate potential threats of internal validity, including response bias and order effects. Order effects of the question. All of the questions in the survey instrument, including the media recognition items criticized by the government, were carefully selected based on how pervasive each item was in the coverage. Footnote 16 says, for example, have you read, seen, or heard if Bryan Kohberger was arrested at a parent's home in Pennsylvania? But by saying that, can't that okay. That's for the state to argue. None of the media recognition items included any information that was not widely reported and available in the public domain. The rest of the survey focused on respondents' opinions of the defendant, prejudgment, and experiences during the search for a suspect. That's generally evaluated by the court with the court-structured survey. This makes me uncomfortable. The survey measured residents' exposure to media coverage, the extent of their case knowledge, and their opinions regarding the case. These questions are normally crafted with the court and the defense and the prosecution all together. The survey was conducted by Research Strategies, Inc., a consumer public opinion and business-to-business market research firm, for 36 years. Their data has been used in 49 district, federal, and district and federal courts, U.S. Department of Justice. Okay, but what were the questions? It goes on to say to successfully win a change of venue motion, the defendant needs to demonstrate that the media coverage has generated bias in the community that undermines his or her constitutional right to a fair and impartial trial. The standard method for measuring prejudgment and fixed opinions within a venue is a community attitude survey. Don't you need the permission of the court, though? There is no other accepted scientific method for doing so. By preventing the defendant from completing this survey, the government is impeding his ability to collect data required to meet his burden. Can't you do this during voir dire? And why not? I have questions. Let's see. The survey designed methodology I used in this case comports with the surveys I have presented in numerous other cases, but did you present them to the court before you presented them to people? For example, in California versus Quentin Ray Beeler, the court granted a change of venue largely based on findings from my telephone survey, which were cited throughout the decision, stating that, quote, Dr. Edelman appeared to use a measured objective analysis of the basis for the change of venue. Okay. The Beeler court also found me to be an experienced expert in the area of change of venue. Okay. In the United States versus Sablin, the court concluded that, quote, the potential for influence creating bias is apparent as reflected in Dr. Edelman's survey. Indeed, Dr. Edelman's survey shows actual bias in more than half the potential jury pool, footnote 19. And that cites the case and the motions. I wonder how many cases he's worked on that don't find bias. The notion that polling 400 community residents, 1% of the Latah County population, 18 and over, is the cause of potential bias in a county that has been saturated with hundreds of highly prejudicial newspaper articles, television news stories, and social media posts is not credible. Unlike the media, individual residents do not serve as a communication channel for disseminating information across the county. There is no evidence that conducting the survey has had any impact on the master list of prospective jurors or potential veneer in this case, the veneer being the potential jury pool. The survey in Latah County has already been completed. I want to know what Judge thinks of that. Hey, Judge, the shit's out of the horse on this one, guy. Ugh. It is my opinion, unless the government is willing to concede the point and waive the issue, that it is necessary to complete comparison surveys in alternate venues. This is the only method for demonstrating that there are counties in Idaho that are significantly less biased against the defendant than Latah County. So did you find bias? That's the declaration. This is the CV. Professional experience. There's a lot of it. We're not going to go through the whole CV. When the court inevitably holds an evidentiary hearing on that, we'll get to hear him go through all of this on the stand. But this has a number of his cases up on the screen so you can read it. Some high profile cases here that you may have heard of. Let's see if anything jumps out at me. Nicholas Cruz in Florida. That was just a penalty phase case, but it looked like there were multiple surveys done there. A case with Boeing. Let's see. I don't know if there's anything else that sticks out to me at the moment. The problem is I do not remember case names very well. I remember fact patterns very well, but this is a substantial number of cases. Pages and stacks and stacks of cases. Publications and presentations. Let's see. And wait, I can put the continuing education classes I've given on my CV. I don't have an active CV. Why? Because I only do this. Doing this stresses me out because I forget things. But this is a very interesting list of presentations and an extensive one as well. All right. Undergrad degree at Florida State University, Tallahassee. There we go. Let's go to our next motion, shall we? That was so much information. I think that he is very well and capable of doing this work. My question is, don't you need or shouldn't you have the court's permission before starting that? I think we would not be in this circumstance if the survey had come before the court before it started going to jurors. And I think the court is going to be real salty about that. So that was the defense motion to rescind, filed on March 26th. The state responded on March 29th in a few ways. So we're going to go to all of the state's responses. The first is going to directly address that. So let's go to the state's response to that motion and CV. I told you there were 10 filings, which is why we couldn't delve into a masterclass on social psychology today. Objection to defendant's motion to rescind order for failure to provide process. The state objects.
We know. You continue to object. We get it. I don't know if we object. I think we might object. I think the shit being out of the horse is a problem, and that we might object. I think we might.
The state objects to the motion challenging the court's order prohibiting further contact with prospective jurors, which was entered after the state filed the motion, and the defendant filed an objection. Defendants claim that this court failed to provide due process is belied by both the applicable law and the facts surrounding this court's order. Defendant's factual recitation in support of the motion leaves much to be desired, leaving out critical facts that are fatal to his argument. Most glaringly, defendant fails to mention this court's revised, amended non-dissemination order, which this court entered more than 6 months ago after briefing by the parties in oral argument. As relevant here, the non-dissemination order prohibits certain out-of-court statements, including out-of-court statements that relate to the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. Arguendo, devil's advocate. On the other side, I think the argument from the defense might be, we are only asking about what the media has said. We're not asking about the nature of evidence. We're not asking about what might be presented. We're only asking about shit that the media has said somewhere. On March 8th, more than 6 months after this court entered the non-dissemination order, the state received information from a Latah County resident who received an unsolicited telephone survey regarding this case. Declaration and response, we're doing that next. Can you imagine being at the prosecutor? I can. Being at the prosecutor's office and getting a call being like, why am I getting a call from someone on the defense team about this case? Oh my God. I would fall over. The state had little information about the call at that point and did not yet have reason to believe that the defense had violated the non-dissemination order. By March 19th, however, the state learned that multiple other county residents had been called and learned the callers were disclosing information about evidence that would be presented at trial. We need the whole survey. We need the whole survey. We need to know. We need to know. Lisa Thornton in the chat said, I live in a very small county. One key person can act more effectively than the quote unquote media. Yeah, the conversations at the Piggly Wiggly cannot be underestimated. Cannot be underestimated. Well, sidebar. There was a fairly recent high profile Nashville related case of a missing college student. Everywhere I went, Starbucks, chiropractor, whatever. And I don't leave my house much because I'm a streamer. But everywhere I went, people were like, what do you think happened? Did you hear about this? Everyone wanted to talk about it. What about this? What about that? Everyone. And Nashville is fairly large. But when I lived in a much smaller community and things happened, everyone talked about everything. So it was, when I'm driving through Starbucks and the barista's like, what do you think happened to Riley Strain? Like, are you following it? Like, it's heartbreaking. Like, these are the bars I go to on Broadway. Have you been to this bar? Have you been to that bar? What do you think? Like, Literally everyone was talking about it. Truly at the Publix. I mean, there's not a Piggly Wiggly close to me. There's one downtown near the park, but that's beside the point. But I can understand that those conversations were absolutely happening here, but those conversations are, what about this? What about that? You know, people talk. We're humans. We learn through talking. Don't eat that thing. It's bad. Eat that thing. It's good. Like, we learn through talking. Anyway, equipped with this new information, the state has serious concerns that the defense was violating the non-dissemination order, and giving the defense the benefit of the doubt, decided to contact defense counsel prior to raising the issue with the court. I can make that bigger. The defense, we can embiggen. The defense confirmed that the calls were being made on their behalf, and the state expressed its concerns regarding the calls and the information the defense, that the issue, and informed the defense that the issue needed to be raised with the court. We'll get to the declaration in a minute. The state filed a motion seeking an order prohibiting further contact with prospective jurors, and asserting as a sole legal basis for its motion that contact violated the non-dissemination order. Defendant filed an objection the same day that conceded the defense had conducted such a survey and intended that a memorandum in support and affidavit was forthcoming. The court then entered the order prohibiting either party from contacting jurors. The order states the court had, quote, reviewed materials submitted by both parties. So the prosecution is just arguing the defense had a chance to be heard. This further explanation of the facts demonstrated, the court has now scheduled a hearing for April 4th, less than 2 weeks after entering the order. Wait, really? Because that wasn't on the docket. When is April 4th? Is that Thursday? Oh, thank you for scheduling it on a streaming day. Yes. Thank you so much. Thank you so much. Guess what we're doing on Thursday? Miguelina, make a note. We have court on Thursday. Chat, we have court on Thursday. Because I am fascinated. And to everyone who was a part of making this happen, where court dates are getting scheduled on our already set streaming days. Yay. This is just heart hands to whoever set this hearing. I feel so seen. It's very validating for me. So the court has scheduled a hearing for April 4th. I looked everywhere for a hearing order yesterday and could not find one. We're going to check the docket before we leave today to make sure that it didn't pop up, but I am so excited. So that's what we're doing Thursday. This fuller explanation of the facts demonstrates that the court has provided defendant with due process. Due process is satisfied when the defendant is provided with notice and an opportunity to be heard. I think the court's allowed to pause and say, we want to figure this out. Due process is a flexible concept calling for such procedural protections as are warranted by the particular situation. The biggest remedy here is going to be that the court gives the defense more time to file their motion for change of venue. That's the solution. This is not, what's going to be dramatic is how mad the court is that they are doing this without the court's prior knowledge. That's the drama here. This court has complied with due process on the issue by providing defendant notice and an opportunity to be heard at every stage related to attorney contact with the public. Early in the case, defendant stipulated that a non-dissemination order be issued to protect against adversely affecting the integrity of the case to be presented at trial. And then the defendant briefed and argued in favor of a non-dissemination order. The state's recent motion asserted its sole legal basis that the defense may have violated the non-dissemination order by including certain questions in the survey that disclosed information about the case. The defense's objection, filed prior to the court entering its order, conceded that the defense conducted the survey. In light of that information, this court's subsequent order to prohibit any additional contact with jurors, at least until further order of the court, allowed for the defendant to provide an affidavit memorandum in support and quickly schedule a hearing at which defendant can be heard, plainly protecting the defendant's due process rights as warranted. I agree, but I want to hear more about the survey. And that's what we're going to do. I really hope it's in the declaration in response. We have a few more motions to get through. Chat, how you doing? You hanging in there? on this fine Tuesday. We have court on Thursday. I'm so excited. Let's get to the state's declaration in response to defendant's motion to rescind the order for failure to provide due process. That's a lot of words. Comes now the prosecutors responding to the defendant's motion. This is the affidavit. On March 8th, our office received information from a Latah County resident who received an unsolicited telephone survey regarding the Kohberger case. Our office promptly forwarded the information to Moscow PD for a follow-up to interview the person who received the call. Of course they did. To ascertain the nature of the call, to determine who was responsible for the call. So the prosecution didn't know that. The prosecution wouldn't call law enforcement if they knew the defense was doing the surveys. They would call the defense. So a juror reached out to the prosecution and is like, why am I getting a call about this case? The prosecution forwarded it to the police and are like, can you please go ask them some questions? Which indicates to me the prosecution had no idea that the defense was doing this. So the defense was just doing shit. And the prosecution and court did not know. And that is going to make the court big mad, I think. Big mad. Big mad. Several days later, our office received additional information that another resident was contacted by a telephone survey company. Our office forwarded that information to MPD to be included in its follow-up investigation. On March 12th and March 19th, MPD Corporal Barrett Payne provided our office with the results of the investigation into this matter, which consisted of supplemental reports 260-262 attached to the state's March 22nd motion for order prohibiting contact. Oh, the sealed order. We're going to talk about that in a minute. During the time between the initial information being received by our office March 8th and receipt of Corporal Payne's, it's either an excellent drag name or dominatrix name. Like Corporal Payne is a whole situation in and of itself. It's just, I'm sorry, Corporal Payne. It just is. It just is. All right. Emily, moving on. Keep going. The receipt of Corporal Payne's supplemental reports on March 12th and March 19th, our office became aware of two other individuals who received similar unsolicited phone calls. So at least 4 folks have called the prosecutor's office generally to ask WTF, it seems. One of those individuals recorded the call and provided a copy of that recording to our office, which was then transcribed by our office and attached to the state's motion. Oh, I need this motion unsealed. I want to see it all. The other individual provided a 1-page written summary, which was attached to the state's motion as Exhibit C. Oh boy. It was suspected that the unsolicited telephone survey calls were being made at the request or on the behalf of the defense. On March 19th, Senior Deputy Prosecutor Ashley Jennings reached out to Ann Taylor to inquire whether she was aware of the phone surveys being conducted within Latah or with Latah County residents. I believe Ashley Jennings is the one that argued that this was a premature motion. Ms. Taylor affirmed that she was aware and offered to meet with our office to discuss on the afternoon of Thursday, March 21st, when she was going to be in Moscow. On March 21st, the undersigned met with Ms. Taylor, defense investigator Rich Bitoni, Senior Deputy Prosecutor Jennings. During the meeting, Mr. Jennings and I were told the survey calls were being made on behalf of the defense. We expressed concerns. Assuredly. Regarding the nature of the calls and the fact that the calls were affirmatively sharing purported factual statements, as reflected in the state's motion and its attachments, that is sealed. We explained our concerns regarding contacting potential jurors and planting purported facts in the minds of these potential jurors who may have not heard the purported facts previously. This is particularly disconcerting because some of the quote-unquote facts referred to in the phone surveys are not true and consequently would create or could create a false impression or understanding within those Latah County residents and potential jurors. Yeah, that's the concern. I love all of the Payne last name conversation happening here. Love. We told Ms. Taylor that our office felt this information needed to be brought to the court's attention, again indicating that the court did not know this was happening. The prosecution did not know that this was happening. Individuals from the county reached out to the prosecutors to ask, why are people calling me asking about the case? Because they were probably concerned. Wouldn't you be? If you lived in Moscow, some of you I think do, if you got a phone call about this case, wouldn't you be like, what the sus is this? Like, sus. I would be. I would absolutely want to know why I was being called. Like, also, who has my phone number? Why do you have my number? Oh, the woodpecker has chased off the blue jay. Why do you have my number? Why are you calling me? Like, I have gone so far down the rabbit hole of this. It used to be that I begged my parents, sidebar again, begged for a separate line when I was a teen. Had to have a separate line. Had a Lips phone. One of the law nerds sent me one. I have it back here in the shelves. I'm going to have to show you what's in the shelves sometime. Had a red Lips phone. I now have a purple iridescent one. It's glorious. Wanted to talk to my friends all day, all night, all the time, on the phone, nonstop. Now, if you call me, I want to know if someone has died. Like, why aren't you texting me? Send me a voice memo. Why are you calling me? Why do you ever need to call me? Why is my phone ringing? And coincidentally, my iPhone, I love my iPhone 15 Pro Max, but the phone calling on it is trash. Like, my service is trash. Trash. Because I don't think this phone is made to call people anymore. Occasionally, when I am driving, I will return a text message with a phone call. I started by apologizing. I'm so sorry to return your text with a call, but I figured we needed to chat. And I'm driving. But I will normally send a text and ask, do you have time to chat? I very rarely just call people out of the blue unless it's my mother. But like, why are we talking? I have gone from, I need a separate phone line to talk to people all day long to, why are you calling me? Ew. So if someone's calling me out of the blue to talk to me about a case in a jurisdiction where I live, I am going to be very concerned. Very concerned. Like, do you need to schedule a doctor's appointment with me? Fine. The prosecution, getting back to this motion, says, we told Ms. Taylor that our office felt this information needed to be brought to the court's attention, again, indicating the court does not know. We proposed sending a letter to the court and attaching copies of the information received with copies to the defense. Ms. Taylor expressed concern regarding this procedure, indicating that she would want to respond to the information prior to the court ruling on the matter. We then discussed an alternative method of filing a motion with the court with the same attachments. Taylor again expressed concern with our office providing the court with anything before an actual hearing. You have to have a motion to have a hearing, generally. We explained that a motion with supporting documentation is standard practice and that it's the route we would be taking. Yeah, we're filing. We're filing. Following our meetings with Taylor, we consulted our attorney staff and decided to proceed with filing the motion with attachments. That motion was prepared and filed shortly before 2:30 the following day, Friday, March 22nd. So the state's again saying, on March 8th, we became aware that this was happening. We asked the police department to interview folks. It took till the 19th to really understand that now 4 people have come to us and said, yo, these are the questions we're being asked. Then they talked to the defense, then they filed the motion. It's not that they sat on this information for 13 days, as the defense seemed to argue. The state submits this declaration in order to clarify for the record what has occurred in relation to the unsolicited phone calls being placed to Latah County residents and to correct certain representations. You can hear it. And to correct certain representations contained in the defense motion to rescind. No, Your Honor, the prosecution didn't sit on this to hamstring the defense. We investigated it. It came to our attention. And then we went, we need to tell the court. And the defense was like, you don't really need to tell the court. And the prosecution was, we're telling dad. Judge, the defense is calling jurors. Stop it. Okay, we have 2 more motions. Told you there were 10. This should have been the only topic today, but, we had to talk about Murdaugh. Okay. Did we do this one? I can't even remember. Yes, we did the defense motion. We did the defense motion. The defense motion in opposition to the state's motion was the one with the CV and all the social psychology. Great. The state filed another motion to unseal their motion. The state filed a motion to seal. The state now would like to unseal. The state's like, well, if we're putting all this shit in public, let's just air it all out. Literally. Motion to unseal state's motion for order prohibiting contact with prospective jurors. Comes now the state of Idaho through their prosecutors. In support of this motion, the state respectfully represents to the court as follows. The state asks that its original motion, I'm not going to read the entire name anymore. I'm tired. The state asks that its original motion be filed under seal pursuant to the Idaho Court Administrative Rule 32 for the reason that the attachments to the motion identify certain residents who have received unsolicited telephone survey calls regarding this case, and the state felt it was appropriate to protect the identity of those individuals. The state was also concerned that the nature of the unsolicited telephone survey contacts contained information that could violate the court's non-dissemination order, including information that is factually false. Subsequent to the state filing its motion under seal, an interim order was issued by the court properly prohibiting the parties from contacting prospective jurors at least until the state's motion was heard and decided. Following the issuance of that order, which did not contain any information that would violate the non-dissemination order, nor any factual information that was untrue, the defense filed a motion to rescind the order for failure to provide due process on March 26th. That motion, here comes the state being like, Your Honor, and then the defense did this, and then the defense did that, Your Honor. That motion contains representations that are either inaccurate or misleading as to the events leading up to the state's March 22nd motion. Unfortunately, the defendant's March 26th motion was not filed under seal, so anyone reading the defendant's motion, whether private citizens or media, we're both, will have the erroneous or incomplete understanding of the circumstances leading to the state's motion, Your Honor, and then they didn't file theirs under seal. We filed ours under seal, and then they didn't file theirs under seal, and now they made us look bad. So now I want you to unseal our motion because they made us look bad, and anyone on the internet can read it. I am anyone on the internet. We're reading it. So now you need to unseal ours so that they can look bad too. Your Honor, damn it, unseal ours too. Based on the above, it's proper and necessary that the state's motion be unsealed so that the publicly available record in this case is more complete and accurately describes the relevant circumstances and events provided. However, the attachments remain sealed so to protect the identity of the named citizens. You could just redact the names, sir. Excuse me. Counselor, just redact the names. Just redact names and addresses. They could be prospective juror A, B, C, and D. What do you think? I don't think they need to be entirely sealed. We want to know what the defense is asking. What are the questions? You can protect the identity by, redacting those things. They don't have to be sealed. Nilda in the chat said, wow, it truly is. Mom, he's misbehaving. It really... Mom, mummy, mother, mum. Your Honor, they filed theirs unsealed. Unseal ours too. Yeah, Your Honor, let's unseal it all. Mention it all. The state also filed a reply. Not sealed. I bet there's more information in here. Let's find out together. Yeah, we definitely want the call. And not the Backstreet Boys song. Though it does kind of slap. All right. Reply in support of motion for order prohibiting contact with prospective jurors absent leave of court. This is the state's response to the defense's opposition that included the CV of Dr. Dude, social psychology. The state submits this reply to address 2 major flaws in the defendant's memorandum. They're so mad. First, defendant's explanation of how the survey complies with the non-dissemination order does not withstand even the slightest scrutiny. Well, we don't know. We don't have all the facts. So please tell us more. Defendant argues that hiring a professional firm to conduct prospective juror to contact prospective jurors in Latah County and ask questions embedded with specific facts from the case does not violate the non-dissemination order because the embedded facts were already quote unquote disclosed by the media. But with respect to both attorneys and their agents, the non-dissemination order prohibits any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication that relates to several categories of information, including the identity or nature of evidence expected to be presented at trial or at any sentencing phase. Defendant's interpretation that his attorneys and their agents can discuss with prospective jurors anything the media is already discussing would eviscerate the non-dissemination order. Oh, the prosecution is big mad because the damage is already done, right? The shit's out of the horse. If the prosecution did this, it would be a huge issue. There's not much the court can do to the defense here. What's the court going to do? Grant the change of venue? That's what they want. Sanction them, they'll appeal it and say that the court is biased against the defendant. Like, what can the judge do here? Nor can the defendant credibly use the cover that the survey is asking questions rather than making statements. The mere fact that, quote, the identity or nature of evidence is being presented to the prospective jurors in the form of a question does not bring the survey into compliance with the non-dissemination order. The specificity of the facts included in the questions implies to the prospective juror that there is, quote, something to see here. Undoubtedly, such questions would draw quick objections in the voir dire process. And this is why surveys are generally decided between the prosecution, the defense, and the court. Defendant also badly asserts that the non-dissemination order expressly allows the conduct in which his attorney and agents have engaged, but he fails to quote or even cite the portion of the non-dissemination order he believes authorizes that conduct. No, they just cite what the prosecution cited and said they interpreted it wrong. The state's best guess is that the defendant is referring to paragraph 2, subparagraph E, which allows attorneys and their agents to, quote, request assistance from the public in obtaining evidence and information necessary to the state's case or the defense's case. Oh, my sky's getting real growly. Clearly, however, that subparagraph is a reference to general requests made to the public to obtain evidence or information about the case. For example, attorneys or their agents could put out a statement indicating they're looking for any persons who were present at X location on Y date. Nothing in subparagraph E authorizes the attorneys and their agents to target prospective jurors and share with them specific facts about the case and then ask, have you heard this? Don't worry. As we get to questions, I'm going to put up a poll about this. Second, much of the defendant's memorandum and the entirety of the affidavit submitted with the memorandum are an attack on an argument the state has not made. We don't misunderstand you, you misunderstand us. The memorandum and affidavit go to great lengths to explain to this court that, as a general matter, jury surveys are not inherently improper for the purpose of a change of venue motion. The state has not taken a contrary position. Footnote 1. The state questions the usefulness of such surveys, but the weight, if any, that should be given to the survey is not at issue here and will instead be addressed during a change of venue briefing. Instead, the sole legal basis for the state's motion is that this particular case, this court's non-dissemination order, prohibits certain questions defendants, attorneys, and agents choose to include in the survey. Given the state's, this court's, and at least up to this point, defendant's agreement that the non-dissemination order plays a vital role in protecting the integrity of the trial, the state filed this motion to bring this matter to the court's attention. The state is pissed. I will be very interested to see if the state's motion gets unsealed. Before we get to questions, I'm going to go see if there is anything new filed in Idaho and make sure there was so many things filed in the last week or so while we were covering other stuff. It was like, as I went to I was like, what is happening? And maybe I just haven't been paying close enough attention to this because all the Ruby, Frankie, Jody, Hildebrandt stuff was going on, but I haven't seen anything talking about this really, and I probably missed it, but I have not seen a lot of discussion between Diddy and Jody and freaking Corey Richins. We've been real busy with nonsense. And then Murdaugh, this kind of slipped right under my radar. Let's see. Last filing is from, no, that's in the Daybell case. I scrolled too far on the court's docket into a whole nother case. Reply in support of the order prohibiting contact from March 29th. All right. There's nothing new in the last 2 days. The state's pissed. The shit's out of the horse. They already completed all the surveys in Latah County. I guess we're going to see this go to court on March 4th. So if you would like to know when I'm going to stream on the 4th, you have to have the Lawnerd app. Have to. Because I am going to have to contact the court to try to figure out when that's going to be, because there's no notice of hearing for that date. It might pop up tomorrow, but the only notice of hearing is for May 14th at 1:30. So I don't know if this is a morning case or an afternoon case. I don't know if it will be streamed. It should be. It shouldn't be sealed. So I'm going to have to find out that information. So you're going to need, April 4th. Sorry. So you're going to need the app so that you know when we're streaming on Thursday. I will adjust my stream time so that we can cover this court hearing. So that might mean streaming in the afternoon. That might mean streaming in the morning. But once I get that information, I will let you know. So April 4th. I haven't changed over months yet in my brain. Apologies. So let's see if we can summarize that real quick. In the 10 filings in Idaho, it is very clear that the defense has completed 400 telephone surveys of the residents of Latah County, asking them about this case in support of their motion for change of venue. It also became very clear that the state was unaware that this was happening, that the state had no input on the questions that were being asked, and the court was unaware of this. The state, in one of their motions, indicated that there will be a hearing on this matter on April 4th, 2024, and I am fascinated to see what the court has to say. The court issued an order the day that the state brought this to the court's attention, saying that neither party can have any contact with prospective jurors, but the shit's already out of the horse on that one because all the 400 surveys in Latah County are complete. The only reason the state knows about this is because members of the public who were contacted brought it to the state's attention. And it became clear that more than 4 people came to the state and said they were being contacted, disclosed the types of questions they were being asked, and one resident of the county recorded the phone survey when they were called. It's going to be very interesting to see what the court does with this, because the defense did not have the court's permission. Generally, when we see surveys happen in cases, the input is from the state, the defense, and the court. The defense argued that this is all very normal and maybe y'all are unaware, but we know what we're doing. We have to survey the jurors to make our motion for change of venue. The prosecution says this looks like it's violating the non-dissemination order, and there are concerns that now that this information is being asked, that it is now given information to the defense or given information to the jurors or potential jurors in Latah County. And thus, it's going to be a self-fulfilling prophecy that maybe there wasn't an issue before, but now that this survey's been done with 1% of the residents of the county, that there is an issue. But either way, you generally see a change of venue motion, and this is what the state argued at the last hearing. You generally see a change of venue motion with information from juror surveys that are sent out by the court. And those surveys are agreed upon by the defense and the prosecution. And if there are things that are not agreed, the court rules on it and then sends out the survey. It's very interesting to see this survey go out without prior court approval, which very much seems to be the case here. I'm very interested to see what Judge has to say about all of this and how they can rectify the situation, because there's not much the court is going to be able to do. If you change the venue because of the issue, then the defense has forced the error that they were seeking in the first place, which is a real interesting thing, isn't it? I'm curious to see what the court does. But for now, We need to get to questions. A number of you have asked in the chat, what can the court do? There's not a lot. Pamela the Camel hit the nail right on the head. Ann Taylor seems like she's going to ask for forgiveness instead of permission. Yep. But there's not much they can do. Can the Bryan Kohberger defense be held in contempt? The court is going to be very, very hesitant. And I imagine that this is not a situation where it is clear that they're violating the non-dissemination order. I imagine that this is going to be very gray zone. The court has to be very, very, very careful of what they do. Charlene, thank you so much. It says the hearing is at 1:30 April 4th. Perfect. I didn't see that anywhere. I will go back through and look on the docket for that. Thank you. I've only looked at the filing docket. I didn't look at the court docket. So thank you. That will very much help. Let's see. Question, what do you think of Ann's tactics here? I'm going to put up a poll. I want to know what you guys think. When it comes to contacting members of the public who are potential jurors, ask forgiveness does not work for me. And I have not seen this done without the court's permission, but I don't know the law in Idaho well enough to know if this is permissible without the court's permission. I think Judge is going to be mad. Does this strike you as a bit shady? Wait, here, let me make the question better. Does the defense contacting potential jurors strike you as a bit shady? All right, that's the poll. Does the defense contacting potential jurors strike you as a bit shady? You know, is it Slim Shady, the real Slim Shady? I want to know. I think the judge might be big mad. It's on the updated case log. Thank you, Charlene. I appreciate it. Thank you very much. So it's, I don't like it, but I don't know if there's much the court can do about it. Cindy Y said, thank you for keeping me and my migraine company. Cindy, I hope it resolves quickly. Those are the worst. Lauren said, YouTube newbie, this channel and community is fire. Chat is bae. The law nerds are the best. And thank you. This is, we absolutely love it here. Spicy Meatball said the court can stop them from doing surveys in counties to obtain comparison data that proves their point. They can, but does that ultimately harm the prosecution's ability to argue too? So I don't know. I don't know. Could the judge deny the change of venue due to this? I don't know if that would be sufficient reason to deny the change of venue. The court could say the defense hasn't proven that there's an issue here. So we'll see. Could the judge remove the non-disclosure order? I don't think that's going to happen. I mean, the judge could, but I don't think that's going to happen in response to this. I don't think that's going to be the solution he looks for, but I do think he's going to be mad. If they make this hearing sealed, I am going to be so mad. Alan, oh my God, your Easter eggs are so great. Been watching you since Daryl Brooks. You keep me company at work. A long time replay crew. First live. Alan, isn't live so much fun? I hope you had the best time in the chat with all the law nerds. Angel said, good evening from Varna BG. 8 months for being a law nerd is fun, and you make US law so much fun and understandable. That is always the goal here. Always the goal to make it understandable. Brandy Rose said, happy Tuesday. We are gearing up for a nor'easter here in Maine. Also, I sent you a wonderful fuck around and find out video on Insta. I'll go find it. I think the law nerds will appreciate it. We are midway through weather. Let's see what we've got all of the thunder, the lightning, the things happening. But let me check my weather sources and see. We haven't gotten any rain yet, which is interesting in my direct location. But let's see. Ryan Hall is probably live already, so I will go check in on that when I'm done streaming. Let's see. We have we are in the not terrible wave. The more concerning wave is yet to come. So let's see. We have a more concerning wave coming in later. All right. For now, it's just grumbly and rumbly. Stina G said, can Murdaugh use the trust from his dad to pay attorney's fees? Maybe. And it still be untouchable for his victims. Probably. But the area of collecting judgments out of a trust is not my specialty. There are others. Law and Lumber is one of them, but there are others who deal with the money much more. I've never dealt with having to collect civil judgments. It's an entire separate area of law. So that it is possible. Question, isn't there rumblings another lawyer is involved, hence polygraph not being released? Ginger, that is the assumption that there could be other lawyers involved, but it could be others that aided Murdaugh. That could be lawyers, that could be bankers, that could be anyone. But yes, the rumbling is that obviously there are more involved, and that's why the government didn't want to disclose that. Terry said his speech to the court seems confused. His addiction happened because he was stealing, or he stole because of his addiction. It just does not ring true. With a lot that Murdaugh says. Sassy footnote. Thank you for the super chat. You don't have to super chat me on your birthday. EDB for my birthday today. Best gift ever. We're here on a Tuesday. I'm so glad to see you. So happy birthday. Good to see you, Nate. Carrie said, what's the SBF and FTX cases Emily refers to? Carrie, I'm sorry I didn't slow this down a little bit earlier. I have not covered them a ton. FTX was a cryptocurrency exchange and fund that went into bankruptcy and collapsed. I have covered the influencer lawsuits where influencers promoted FTX, the crypto exchange, and sometimes the cryptocurrency. SBF is Sam Bankman-Fried, who was the head of FTX, who was recently sentenced for the fraud that was involved there, most of which came to light because of the bankruptcy. Law and Lumber has covered it a lot. I've covered it a bit, but I've not covered it as much as he has. I'm interested in the influencer lawsuits. So when I covered the BitBoy crypto stuff, part of that was these influencer lawsuits with regard to FTX and promoting FTX. A lot of influencers, from like internet influencers to traditional celebrities like Gisele Bündchen, Tom Brady, and others, were all sued for promoting FTX by people who put their money into FTX because of the celebrity or influencer endorsements and then sued them. Other celebrities were also in trouble because it was these are deeply nerdy rules, but because it was promoting a financial token. And when you promote a financial token, you have to disclose how much you have been paid to promote the financial token. So there are different rules than just disclosing like this is a sponsor or this is an advertisement. There are different rules when it comes to financial tokens. JT Baller in the chat. I covered this at the beginning of today's stream. It's tomorrow's podcast on Diddy. Sarah said, don't sleep through tornadoes like my dad did yesterday, causing a sleepless night. I will not. I am generally the one that is weather awake. I also very much enjoy lightning. So I am generally the one who is weather awake in my household. Because I wouldn't sleep anyway. Thank you for the gifted memberships. Carl Labine, 83. I appreciate it. Good afternoon, emotional support law nerds. Christine, we are here. Lil Bill McGill said, catching up, but I'm also a Taurus, sun and moon. What's your rising sign? Mine is Cancer. Love being in good company with EDB. Gosh, I always forget. Is it terrible that I always forget? I always forget. I'm going to answer this question even when I forget because my brain is just absolutely blanked. But it's like me and like 4 of my friends all have the same rising sign, and I always forget. My rising sign is Virgo. Like me, Judge Abby, and others. I'm very earth sign heavy for everyone who is interested. Taurus, Virgo rising. And Belle, good to see you. Army, wife, military, time trick, ignore the 1, subtract 2, 1727 becomes 527. And because they tried to add the extra digit PM, this works for 1 PM to 7 PM. Thank you. Let's see. Michelle said, I never heard about sentencing questionnaires early. I thought for some reason, what Murdaugh team had done when trying to change venue. Murdaugh's team, when trying to change venue, there's loudness going on in my house. Everybody's home because school got released early. There is that is normally how it happens. The way it happened in Murdaugh is that they send the surveys out or the questionnaires out for the jurors. They come in, and then if there's a noticeable issue, then they make the motions. That is generally what I have seen happen. These defense attorneys who have done an excellent job of zealous advocacy. I don't always agree with the way that they do it, but these defense attorneys practice in this jurisdiction much, much more than I do. So, I'll be interested to see what the requirements were on what permission you need from the court before you engage in that. So, yes, I am very, for those of you in the chat who are like, oh my God, earthy. I am very earthy. all. Nikki said, how appointed attorneys getting experts like this paid through taxpayer funds? They get it approved from their office and are allowed to do it. It's a death penalty case. There are a lot of experts that they need for a death penalty case. Death penalty cases are tremendously expensive to try, but the defense obligations in a death penalty case are very, very, very high. And because of that, you will see most of their requests getting approved to pay for it, but those are paid with taxpayer funds the same way the state's experts are paid with taxpayer funds because the state's experts come from law enforcement. So, let's see. May said it's okay to love people with opposing political views. That was per our earlier discussion about conversation and cognition, which was, I thought, a helpful discussion. Jilly Bear said, not sure if you knew, but apparently Alec Murdaugh's mom died not that long ago, weeks, and apparently the prison let the funeral home bring her to the prison chapel for his goodbyes. Huh. Never heard of this. Is this SOP at prisons? I have no idea. I have never worked in the prison system. I've never heard of it happening. But I have no idea. I mean, there must be some procedure for it because they allowed for it, but that's unique. But they're not going to let him out to go to a funeral. My favorite saying is this Luby Lou online, this was fantastic. No one is listening if everyone is shouting is absolutely fantastic. My tattoo artist told me that he prefers to have conversations with me rather than his friends because when I disagree, I don't stroke his ego. We can just disagree kindly. Like you can do it kindly, but without like, I don't know, placating someone. Mannix said, it's Little Planet. BTW Dwarf Planet is offensive. I mean, okay, it's Little Planet. Lynn said, got here late. If M were to get a new murder trial on appeal and found innocent, would M still have to serve the federal time? Yes. He would have to serve all the financial crime time. Carrie said, how has it been a month already? Time flies when you're having law. Creekside said, isn't Bryan Kohberger's attorneys public defenders? They are public defenders. They still have access to experts because their obligations for trying a death penalty case are very, very high. Did you see Runkle broke Rob last week? I did not, but I'll look. Can the DA ask if they were contacted in VD later? I don't know what VD is, but I don't. Oh, Valo Daybell, I'm guessing. Not after the case is done. That would be part of the veneer surveys. Tina said, lost my 19-year-old Pawnard last night. Thank you for taking my mind off of it. Tina, the loss of a Pawnard is, thank you, chat. Tina, the loss of a Pawnard is uniquely painful. It changes the way your house feels. I am very sorry, but 19 years is a lovely, lovely amount of time to love your Pawnard, but I feel you. It is uniquely painful. The chat has said during voir dire, yes, when it comes to voir dire, they can ask if people have been contacted. I imagine this video, the light in my office has changed so much. Ellie says, just joined, can't wait to be a replay crew later. I mean, there's always time. We always stream for, enough time. Casey Cat, wouldn't contacting a maybe potential juror pool just encourage every person surveyed to research the case they were just contacted about? It would for me. Wouldn't you? I don't know. I might. Jordana said, longtime fan, first time actually catching a live. Thanks for all you do. You're welcome. Isn't the live experience so much fun? Melanie said, also my first live after a year of being in the replay crew. Thanks for keeping it real, Em. You're a gem. Well, thank you. You are a gem as well. The law nerds are the best place. We're going to get into live trial coverage again soon. So I am going to be zooming through the cases that we've covered so that we can start gavel to gavel court coverage in like 2 weeks. Hello, Lay said off topic, but would love to hear your thoughts on the McGirt versus OK Supreme Court ruling from 2020. No idea what that is. No one in my real life wants to talk about it with me. I have no idea what that is. I'm sorry, Hello Lace. I don't I pay a lot of attention to trial level courts, not as much of attention to appellate level courts. The trial level courts, A, are where I practiced, but B, are just the strangest stories. Like the things that are woven throughout courts is fascinating. Sonia said, my dad has been an attorney for over 40 years, and he said one of the most disgusting things an attorney can do is steal from their clients. I think it's the top. It is the top. It's why the like number one thing that gets you disbarred is taking your client's money. It's what when we talk about which one's more despicable. I mean, I have thoughts for both, but Tom Girardi stole for longer, and the amount of corruption that protected Tom Girardi, I think, is worse. When the state bar in South Carolina found out about Murdaugh, he was disbarred in pretty short order. His law firm immediately fired him. Girardi had hundreds of complaints, and I went over the things that were released from the state bar. The state bar had hundreds of complaints about him, lots of them about stealing money, and did nothing. That level of protecting him is just absolutely appalling. Kimberly Rudd said, it's my 23rd work anniversary. Awesome. Oh, the birds outside did not like that. I don't know if you guys can hear the thunder yet, but it's getting closer. Question, were there any proceeds from the sale of Moselle? If so, who got them? Moselle was in Maggie's name, and it probably went into a trust for Buster. So that. Captain Wee the Barmy, good to see you. Octo Nation, I ordered your book. So excited. It's a beautiful book. Beautiful book. Madam H plays at Disney in the middle of the Reed trial. 2 out of 10 timing. I'm sorry. It's okay. It'll always be here for replay when we get through it. I know there are pre-trial hearings coming up, but in the Reed case out of Massachusetts, the court has denied like 5 motions to continue. Like the defense and the prosecution keep asking to continue the case, and the judge is like, no, we're going to trial, which might not be a great strategy because no matter if Reed is convicted, then that will be another reason for appeal. But it's a bold strategy. Debbie Blair said, Emily, your thoughts on if another attorney was involved in Murdaugh's shenanigans? I mean, we know there were other attorneys that were helping him move stuff. I don't know if there's enough to prove that they knew. We heard from Chris Wilson at the trial, and he started getting suspicious about stuff, but I don't know if he was if he was just like, okay, well, he's asking me to do it this way. That's fine. But I don't know who else they're looking at. We'll just see. But if they were looking at like Murdaugh's own attorneys, I don't think they would ask for it to be unsealed. So I saw speculation about that online, which is the only reason I bring it up. Laura M said, question, can we get toddler sizes for some of the shirts? I have a little who I want to put in a shirt. Thank you for everything you do. We will look. I have to look at our distributor and see what we have with regard to kid sizing. Kevin said 20 minutes late watching at 2x speed to catch up. Good luck with that. I talk very fast on a good day. Dawn Shoot, thank you for the gifted memberships. Dawn Shoot also said we're expecting bumpy weather later. The bumpy weather is coming. Bring the jar. We definitely had coffee. Happy early birthday, Naomi RG. Good to see all of the members in the chat. Jennifer Baker immediately. Where's Fred's attorney? Fred's attorney definitely popped in. Leela said, who needs enemies with a quote unquote friend like Alec Murdaugh? Luckily, we have Emily and the Law Nerds. It's such a pleasure to be here with y'all. Same. Rachel said, as the thunder rolls, please let us know via the app that you're okay later tonight. I will. We have definitely been smooth going, but I will keep you guys posted. RK says, for the Pismo Beach disaster relief. Thank you, RK. I appreciate it. So for all of you that are in bumpy weather zones, buckle up, stay aware, have your alerts, charge your phones, and I hope all is well and nothing is devastated. Cumulus Cloud said, lest we forget, Chris Wilson told us Alex said, I shit you up, and now I can't listen to Rick Astley ever the same again. That's right. Damn it, Chris Wilson, why? Why? He did say, I shit you up, and we were all like, what the fuck does that even mean? Like, what does it even mean? I saw another question I wanted to pull up. Mick Hughes headphones said, Emily, have you followed Delphi Insanity? I have been loosely looking at the legal wildness that's happening. At some point, I would like to be able to catch up and break it down. I just haven't been able to get caught up. There's a lot of legal shenanigans. Like, aside from the facts of the case, the legal wrangling in that case is absolutely wild. So Aaron said, I'm in Knoxville. My daughter told me be careful. It's always nice when our kids check on us. Zelda said, suggestion on live streams, put the topic on the screen so latecomers know what's being discussed when tuning in. Zelda, we put it in the pinned chat. So it is always in the pinned chat. I appreciate the suggestion. Sometimes that distracts me, but it is always in the pinned chat. So we do put the topics there, so you can always see it just right at the top of the chat. But I know there is some stuff going on with comments that YouTube is working on. I would love it if YouTube works on a way that you can come in to the chat and just ask what the topic is and see it. I think it would be super cool. So with all of that, and 3 hours in, I'm probably going to go watch some of Ryan Hall, y'all. I'll probably see some of you in the chat at some point today as I peek in on his stream. He covers weather all over Tornado Alley. And that is always incredible. For those of you local to Middle Tennessee, Nashville Severe Weather does incredible work. They stream on YouTube. They also put stuff up on Twitter. It's truly one of the reasons I keep a Twitter account is so that I can follow Nashville Severe Weather. We haven't ended the poll yet. We need to do that. Does the defense contacting potential jurors strike you as a bit shady? 95% of you said yes. 5% said no, with almost 3,000 votes in the poll, with over 9,000 of you still here on stream. So with all of that, let's see. Does anyone have the date for the texting judge stream? I can't find it in the app. It gave me chuckles, so I want to rewatch it. I always call the texting judge case texting judge. So if you put it in search on YouTube, you should be able to find it pretty easily there. So with all of that, Law Nerds, you are the best. We're going to court on Thursday. I'll update you in the app what time our court appearance is. It looks like it's going to be a little bit in the afternoon. So we will shift our streaming time to the afternoon. Hopefully I don't have any obligations in the afternoon that I have to move. We'll see. It's an adventure every single day. Live streaming is dynamic. You're the best. Stay safe. I will talk to you soon, and I will update you in the app later today. Hopefully these rounds of storms will pass before too late in the evening, which is what I think will happen. And I'll talk to you soon. Bye, Law Nerds. See you in the next one.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.